I beg to mention for listing of the case mileage and the contractual bill mileage. Like about 20,
Huh?
20.
What is what date? Oh, today is 11th. What is the urgency? So many matters pending.
Was the matter already settled matter, my lord. They have to release the money.
Huh?
It is a matter is admitted matter, my lord. They have to release the money only.
Okay.
Yes, please. I did to mention for listing matter on witness the matter.
What?
My IA case is pending for pending since.
IA for what?
2022. For substitution.
Huh?
Substitution petition.
For no, not Wednesday. Give a date. Friday.
May I please, Lord?
It's stop Friday.
Yes, may I please, Lord? My lord, I beg to mention for withdrawal of two writ petition that may be listed tomorrow, my lord. Okay.
May please, Lordship. Lordship, I beg to mention for listing of two writ petition, Lordship, on 22nd, Lordship, March.
What is the matter? Pending
Matter
matter.
is pertinent to the non-payment of contextual bill amount, Lordship.
Okay, may I please, Your Lordship. Your Lordship, I beg to mention item number 9 and 10, Your Lordship. Your Lordship, in both the matters, Mr. M. Ahmed is supposed to appear, but his driver has expired today morning, Your Lordship. Okay, so he is unable to appear, Your Lordship. Matter may be adjourned.
Mr.
I.H. Lester, on behalf of Mr. M. Ahmed.
But he's in item 9 and 10.
Yes, Your Lordship.
You're right. Adjournment prayer has been made on behalf of Mr. I.H. Luster, the counsel for the petitioner. On the ground that neighbors expired.
Yes, sir.
Accordingly, leave this matter after 2 weeks.
Highly obliged, Lordship.
May I please, Your Lordship. Lordship, I beg for listing of three similar petitions, Your Lordship, initially. The matter relates to non-payment of dues by the PHC department, Your Lordship.
When?
Your Lordship, Friday.
May please, Your Lordship. I beg to mention for listing of a matter.
Offer?
Listing of a matter,
New matter, old matter, what?
new matter. WPC 641 and 662 of 2024
For motion.
for admission.
Missions. That is not a new
Lordship,
matter.
can it be on Wednesday?
Next week.
I do. May please, Your Lordship. I beg to mention for listing of a matter. It is of a non-payment of the bill. So can it be listed on next week, any date?
Give a date. Like,
And I have a similar prayer for another 6 matters, same matter.
you give some of date.
Okay.
May I please, Lordship. My lord, item number 19 will be adjourned for 2 weeks, Lordship. Item number 19.
Why?
Lordship, the engaged council have some personal difficulty, Lordship. 2 weeks any day. Regarding issuance of license of for
Is there a stay order?
yes, Lordship.
Wait, we'll see.
I think also voted.
May I please, Lordship. Lordship, this is a matter of non-payment of contractual bill of PHC. I was supposed to file affidavit, but amount is very small amount, Lord.
It's not a question of small, madam. It's a question of admission. You know that unless it's admitted, how can we direct that it should be paid?
No admission, Your Lordship.
Notice may be issued, Lordship.
Yes,
No admission there's no admission from the department, Your Lordship, from the highest authority. Civil engineer.
obtain instructions.
Yes.
Ms. D. Anjana, learned counsel for the petitioner, submits a contractual bill amounting to rupees 3,83,889 has not been paid by the respondent. Issue notice returnable in 4 weeks. Mr. D. Gogoi accepts notice on behalf of all the respondents.
Lordship, item number 3 is also similar matter, but the amount is.
Item three, same thing, huh? Contractual bills, seriously, same thing. Don't write the amount, that's all. RR Gogoi, RR Gogoi accepts notice on behalf of all the respondents. Huh?
Others nothing.
Lordship has asked me to look into the arbitration clause aspect of this matter.
I have not been able to file it on affidavit, Lordship, but the clause 24 of the contract conditions, my lord, Lordship has a law. It is a bit cryptically worded. It says that there has to be a decision against which I am agree, and only then the dispute resolution mechanism would be invoked. As of now, there is no decision, my lord. There is only a recommendation that this amount additional should be sanctioned. Therefore-
This amount is for which period?
This is, my work was completed in 2021, my lord. What would happen in these cases is that these are the only detention centers we have in Assam for these foreigners who are declared, my lord, by FT. So this was constructed in a hurry, and as a result, my lord, the original budget sanction, which was there available for this project, it had exceeded. So additional amount was recommended to be sanctioned. So that sanction proposal is still pending, my lord. My prayer therefore is that that should be sanctioned, and then consequently my bill should be released, my lord. Otherwise, my lord, I'm not coming squarely within this dispute resolution clause, because as of now, there is no.
Yes, madam.
My lord, I may be allowed to take instruction, my lord, at least 1 week time may be granted.
Or
my
we
lord.
issue notice.
Lordship, lordship.
Heard Mr. B. Pathak, learned counsel for the petitioner, to submit that the petitioner has not been paid his bill of rupees 28,66,873. Issue notice returnable in 4 weeks. Miss
You does,
Udas accept notice on behalf of all the respondents. This is the matter of the.
public.
Deeply approved.
Where pleasing lordship, my lord. This is a matter, my lord. Petitioner was my lord settlement on the under missing autonomous council, my lord.
Huh?
Petitioner was the settlement on the under missing autonomous council, my lord, which was constituted under the sixth schedule, my lord, of the Constitution of India, my lord. My settlement order, if you lordship go to the my lord, you lordship kindly look to annex, my lord. B,
Page.
page, my lord, 35, my lord.
Yes.
Yes, my lord. After tender was floated, thereafter it was settled with me, my lord. Under the provision of power function of the General Council, Missing Autonomous Council Act, levying Fasik and Mohar in the market modified Missing Autonomous Council, Katanara Min Mahal has been for 15,500 rupees only. The settlement has been given as per recommendation of the Revenue Resource Settlement Committee and approval of Honorable Chief Executive Member for the year 2022-24. Thereafter, the fishery has been handed over to me, my lord. Then what happened, my lord? The government of Assam, my lord, they are floated a tender, my lord, the settlement of the fishery, my lord. We are the small fishery, my lord, who is in the additional channel of the my lord, river, the particular. And
The fishery has been settled with you.
fishery has been settled with
Then-
you. Then government has settled to the another person, my lord, 60% rule, my lord, under Rule 12 of Assam Fishery Act.
60% of what?
60% fishery, my lord, 60%.
You mean to say a part of your fishery has been settled again with somebody else?
Yes, ma'am, that is the issue, my lord. I am not going in all that, my lord. With other person, respondent number 7, my lord. Then, lordship, first of all, lordship. Then,
I'll
think
make
that-
go to before passing an order, Lordship.
Huh?
They are not the sixth schedule, Lordship. Missing autonomous council.
There is none of the schedule.
No, they have no right to interfere in the government affairs, Lordship. Even the Missing Autonomous Council Act also says that, Lordship.
No, this.
Yes,
Acha.
the Missing Autonomous Council has no right at all to interfere in the government. They have no right to settle. They have no right anything, Lordship, in the fishery.
Okay, so this order, settlement order is wrong.
Wrong, and in one of the cases, Lordship, Honorable Court has stayed this type of order, Lordship.
yes, my lord, that was I have annexed, my lord.
No,
Your
Lordship, that was the order which, may I say, Lordship, or you? The order which was annexed by my learned friend, on that day, Lordship, section 18 of the Missing Autonomous Council was gone through, but not other part, Lordship. That is the relevant part. Without going to the relevant part, Lordship, the order was passed. The order which was annexed, Lordship. The order,
Where do you want me to look?
Lordship, first of all, I want to look Missing Autonomous Council Act, Lordship.
I'm looking at that.
I have given this one.
Yes, where? Which section?
First, Lordship, an
Huh?
act, Lordship, to provide the establishment of an act. First,
Yes.
one Lordship. That was been, they had a authoritative administrative which was been strike down, Lordship. In 2001, Lordship. They have an administrative power in 2001. It doesn't
What
strike.
do you want me to, what do you want to show me?
So me, Lord, yes,
You have given me, you see, this thing contains of 22 pages.
yes.
Now, which section, which page do you want me to look into?
Okay, that's page 47, clause 47. Section,
There's no clause, there's section.
section 47. Section 47, Lord. 47.
Yes.
Not, notwithstanding anything contained in section 3, the village council okay, I'm sorry, Lordship, page 81, Lordship. It should be 81, Lordship. I'm sorry, Lordship.
81, there's no 81, Mr. Counselor.
81, Lordship, 81 section.
Huh?
81 section. Lordship.
Section 81.
Yes.
Yes.
Nothing in this act shall affect the application of any law, whether made before or after this act, to the council area, unless such law specifically provides for exclusion of the council area of such application. There is a, in the later part, there is an explanation part. For the purpose of this section, law shall include any enactment, ordinance, regulation, order, bylaw, rule, scheme, notification, or other instruments having the force in law. So we have settled and government is settling by Assam fishery rules, Lordship. So as because the fishery which is under us, they are claiming them as Lordship, the issue here is that missing autonomous council was enacted, Lordship. The area was being notified, but it was not under 6th schedule. But after notifying, they are claiming that this part of fishery is theirs, Lordship. They are settling on their own laws.
So how does this come into play? Who is for this missing autonomous council? What have you got to say? Page 35. What have you got to say? What is your stand? It's under your jurisdiction.
Because earlier this petition has been settled.
By you.
Therefore, my lord, this has been settled.
Okay, right. Heard Mr.
And
NNB Chowdhury, learned counsel for the petitioner, who submits that the petitioner was settled with the Kata Nola Mean Mahal from 1722 to 3624 by the missing autonomous council. However, the respondent number, who is the state government?
State government.
However, the state government has settled a part of the fishery with the respondent number 7. So you are in possession of the fishery.
Yes, my lord, I am the person of the fishery. They tried to evict me from the place of business.
So what have I said? Yes, what have I said? Louder, louder, I can't hear you. Kata number? There's no kata.
Patanola.
Huh?
Patanola mean.
Kata number. Huh. Yes, then there's the comma, a 60% fishery. You know, what is the name? The same name.
That was it, that name is safe for the respondent.
Huh?
Gomori Koboto Cooperative Fishery Society. Respondent number 7.
No, no. Is the fishery name same? By the missing autonomous council and by the state government, is it name? What is the name given by the state government?
State government given my lord, Gomori Koboto Cooperative Society Limited. It was name is my lord. And
The fishery name, the fishery
sorry,
name.
sorry. I understand my lord. The name of the fishery is my lord. My lord. That is my lord.
What is the name of the fishery that you have given? Settled with the spot number 7.
This is my lord.
Same name or what?
My lord, no, my lord. That is-
Next case, you will think
My lord. Koboto.
you find out, then you will come again. Sure. No, after some time. Let him be sure. Doesn't know the facts.
May I lordship?
Okay.
Lordship, non-statement. This is the petitioner's husband, lordship, was the
Petitioner's husband
lordship,
was the
registered contract.
when did he expire?
Lordship, that is 25/7/2021.
25/7/2021. So what is the contract the same thing?
Same scheme, lordship. Liability statement is page 17, lordship.
Yes. 15. No.
17, lordship.
12.
12 lakhs, lordship, 88,042 rupees.
Six nights. Okay. Yeah, it's already here. Just have to correct.
Lordship,
And
item
wait, Miss KK Chaudhary is there. For the CGC, who's appearing? What's your name? Again, what's your name? Miss M. Burman. What is your name?
Miss A. Lodha.
For 2 to 6.
Yes.
7 is similar.
Just let me
lordship.
see. Let me see 7.
Liability statement is page 14, lordship.
Page 14.
Lordship. Amount is 7,75,000.
Your this thing is very unclear. The letter of the, okay, 936, okay. Okay. Okay, done.
Item 11.
11. Come to page 13.
Yes, Lordship.
This seems to be overwriting clear and very clear. Page 13.
Yes, Lordship, date is 30/08/2023.
Overwriting. Where is the original? And look at the, look at your letter number. There's the, what is the number? Nothing is clear. MGWRD W-205 PT 72 2023 slash what?
Yes, Lordship, 1726, Lordship.
Huh? From where do you get 12726?
It's in my phone, Lordship.
And you, huh? Where do you get 1726? In my copy, I cannot read it. You get a, you change it, you have to make an amendment or whatever. Because that 1726 cannot be relied upon by us. At least by this court. Letter number.
Yes, Lordship.
Okay, have you got a good copy? Page 13.
No,
Yes,
Cannot read.
Lordship, I'll provide one, Lordship.
How? You filed an application for amendment.
But to the panel,
Huh?
to the,
You cannot supply like that. It has to be uploaded. So you either amend the writ petition, because it cannot be done like earlier time.
maybe allowed to withdraw and file fresh.
Better, I think.
Yeah.
Better. Ms. KK
With the
Chowdhury.
liberty to file.
Huh?
With the liberty to file.
Ms. KK Chowdhury, learned counsel for the petitioner. Says that she may be allowed to withdraw the writ petition with liberty to file afresh. Ms. M. Burman appeals for Ms. A. Gayan, learned CGC, for the petition, for the respondent number 1. Full stop. Ms. A. Lodha appeals for respondents number 2 to 6. Whereas the petition's counsel is allowed, writ petition is dismissed as withdrawn, with liberty of place court.
Problem.
Okay, yes, what is the thing?
Name is not so. Page 39.
Page
Sorry.
39.
Yes, madam. Saridwar for Tharoi Bill, Meen Mahal.
Page 39.
Second paragraph.
Okay, what have I said? That is 60% of the fish, 60% fishery, 60% fishery in the name of Charidwar, no, Chaidwar, CHIDUAR, Kharoi Bill, Meen Mahal. Page 39, second paragraph, it is there, okay? Under Biswanath subdivision of Sonitpur district. Next paragraph. The petitioner's counsel submits that the petitioner is in possession of the fishery till date, even though attempts are being made to evict it. Issue notice returnable in 3 weeks. Mr. P. Sharma accepts notice on behalf of
Fishery Department.
Of-
Fishery Department.
1, 2,
Government will attend over again.
1, 2, 3. 1, 2, 3.
1, 2, 3. Where 4? Who's 4?
District Commissioner.
Mi- Miss-
5. You done.
Mi-
4 and 5.
4 and 5. Mr.
You go with 4, 6.
D. Gogoi for 6. Petitioner takes step for service of notice upon the respond number 7 by a registered post with AD within 2 days. Full stop. Till till the next date, comma. Status quo in respect of the possession of the, what is that? In respect of the Katanola mean mahal shall remain. Huh?
Lordship, we are like, Lordship, my contention may be recorded, Lordship. My content, they are not on the 6th schedule.
I'm
No,
not
no,
that Uddhayan.
They're not on that. That's not, we'll see.
I'm Uddhayan,
Yes, huh?
I'm Uddhayan that submission. That
Okay.
Lordship, is
Actually, Boro autonomous
as per,
council.
as per Missing Autonomous Council Act does not entitle them to go for settlement. Lordship. That part,
Anyway, we'll see.
Lordship, that part may be recorded, my.
Okay, just put one thing. Mr. P. Sharma submits that the missing Autonomous Council Act, 1995
How 81.
does not provide for, does not give competency to the council, to the Autonomous Council to settle, to settle fisheries with private individuals.
As per 81 of section 81,
As per section 81 of the,
Missing Autonomous Council Act.
as per section 81 of the missing Autonomous Council Act.
As per 18, my.
81.
81,
He was 18, my lord, I'm 18.
Does it matter?
18 of the Lordship here.
I've already given you a stay order. Why
Sorry.
confusing?
Lordship here, Lordship, regarding replying their contention, there section 23, 1 also may be recorded. It is
Forget it. No, you see that next. Right.
like.
This is the matter after 3 weeks.
May I please, your Lordship?
Section, item 6.
May I please, your Lordship?
Yes.
Lordship, the petitioner before you is a contractor, Lordship.
Is that?
He's a contractor,
Yes.
Lordship. He was given a contract to construct a road in the West Karbi Anglong district.
Yes.
Lordship, what has happened in this case is this, that the road, that road falls under the, falls between 2 states, Assam and Meghalaya, and it is a disputed area. When this contract was allotted to him, from that time only, there was a dispute. And when he started the construction, Lordship, there was a police firing. The place is that Mukro, Lordship. There was a police firing and some 6 persons died, Lordship. And later on, Lordship, when
So what do you want now? What do you want?
he has been served with a termination notice, Lordship, for non-progress of work, but there is no fault of his own, Lordship. He has been given a notice by the Meghalaya government that not to construct any road. Therefore, he is challenging this termination notice, Lordship.
Termination order. Where is the termination order?
Page number, Lordship, 102 at Annexure F, Lordship.
Yes. Now, what do you want to? You want to challenge this?
Yes, Lordship.
Is there any arbitration clause
Yes,
in
there is
your contract?
arbitration clause,
Then you go
Lordship.
in arbitration. That's the only way out. This is the this should be disputed questions of fact. Yes, what is to be done?
Lordship, I'm preparing for Karbi Anglong Autonomous Council, Lordship.
Yeah.
At this stage, Lordship, notice may be issued.
Why? When there is a arbitration clause to decide disputes of this nature, why should we go into these issues? Show
Lordship,
me where
this
is
is
the arbitration clause?
Then government of Meghalaya is also involved, Lordship, and once notice has been served.
So how can this court decide? First of all, can a high court decide boundary issues between 2 states?
No, Lordship, we are
Then-
not on that, Lordship.
Then
We are,
your issue is you have been given a work order
Lordship,
by the government of Assam.
Lordship.
Because of some problem with the government of Meghalaya and the government of Assam regarding the boundary, you have not been able to do your work.
Lordship.
Be that as it may, your work has been terminated by the government of Assam.
Lordship.
Now, if you have a dispute with that, what does your contract agreement say? Contract agreement says that you go through the arbitration clause. So you go as per that. There's a provision there. Why should we? Where is the arbitration clause in your
Lordship,
contract agreement?
Lordship, at least notice may be issued, so that
Why?
at least government of Meghalaya should also be involved, Lordship.
No. Sorry. We are not going to go into that issue.
Lordship,
Sorry.
kindly see page number 105, Lordship.
Government of Meghalaya cannot come here. Sorry.
Lordship,
We do not know. That is your projection.
Lordship, kindly see page number 105, Lordship. There, Lordship,
Does the termination, does the government of Assam say that the work could not be completed because you are having problems with the government of Assam, with the government of Meghalaya? Did it say that? It says
they are
no.
not saying that.
They are saying because you are not working. You are trying to broaden the scope.
Lordship, after the firing incident, it was
Maybe.
impossible to work, Lordship.
We do not
Lordship,
know.
Lordship,
This
for a
court
moment,
cannot-
for a moment,
This
Lordship.
court cannot decide that.
Lordship, for a moment, Lordship, Lordship, kindly come to Lordship, page number, Lordship, page number 99, Lordship, where I have been expressly barred by the Deputy Commissioner West Khasils, Lordship, page number 102, Lordship.
Mr. Counsel, if this is a border issue between two states, this High Court cannot go into it.
Lordship, I am
It
not
has
on the
to-
border issue, Lordship. Lordship, for a moment, Lordship, 102, Lordship, page number 102.
Yes, 102.
No, sorry, Lordship, page number 99, Lordship, I'm sorry. Lordship, may kindly peruse page number 99, Lordship. Lordship, may kindly see here that this letter was issued to me by the Deputy Commissioner with.
I am not on that. Your issue is with the government of Assam terminating your contract, not with the government of Meghalaya. Sorry.
But they are
Heard, Mr.
forcing me, Lordship,
Whatever. Your contract has been terminated, Mr. Counsel, today.
because of this, Lordship.
Maybe. Yes,
I am
Mr.
willing-
Nayak, what do you say? Yes,
Tender was of 2020 now.
2020.
Yeah. 31/12/2020, completion period was 24 months. And the termination, Lordship will see at page.
No, Lordship, I was allotted on 4/2022, Lordship. I was allotted the contract on 4/2022.
Is at page 102, Lordship, it's an order of 25/2023.
Yes,
Ah,
your Lordship. And I was-
25/2023.
and it's coming now.
The delay part of it.
Ah.
Why now, Lord? You are
That's what I'm explaining,
seeking-
Lordship. This is not an unexplained, this is not an unexplained delay, Lordship. I'm explaining my,
I've heard you, Mr. Counsel.
Page 84, Lordship,
Yes,
that is our.
okay. Heard, Mr.
PP Mehti, Lordship.
P.P. Mehdi, learned counsel for the petitioner. Also heard Mr.
R.S. Ronghang,
R.S. Rongan for the
Ronghang,
Rohani.
for KAC.
For the Kabiang Long Autonomous Council. And Mr. P. Nayak for the respondent number 1. First up. The petitioner has challenged the termination of his contract work issued by the Executive Engineer PWRD by Thalangso Division, Donka Mokam, by letter dated 25/2023. Next para. The petitioner's counsel submits that the petitioner was awarded the contract work of M and BT and construction from road Khirmi Somatan to Mukro under clause 9.4 of MOS signed between so it's at page 15. Take the subject, subject matter, that subject matter, okay? For the contract price of rupees 8,53,93,302. Next para. The petitioner's counsel submits that as the work contract for the road fell between the disputed boundary area of the state of Meghalaya and the state of Assam, the petitioner was threatened with stoppage of his contract work by the officials from the state of Meghalaya. He submits that there was even firing and loss of life as a result of the border dispute between the parties.
May I please, Your Lordship?
Full stop. The petitioner's counsel submits that he approached the respondents. He approached the respondents, he approached the PWD Assam and the Karbi Anglong Autonomous Council authorities with regard to the difficulties faced by him and requested them to sort out the matter. However, instead of sorting out the difficulties faced by the petitioner in doing his contract work, the petitioner's contract was terminated by the respondents number 1, 2, and 3. White notice of termination dated 20/05/2023 on the ground that he had stopped work unilaterally and failed to show any progress of the work. Full stop. So what are you challenging now?
Lordship, the termination notice
Full stop.
itself, Lordship.
Okay. He accordingly submits that the notice of termination, impugn notice of termination should be set aside. Next. Mr.
R.S. Ronghan.
R.S.
Ronghan.
Ronghan. Ronghan.
R.S.
Ronghan. R.S. Ronghan. Learned counsel for the KAC and Mr. P. Nayak. What is your submission?
The termination notice was served by the executive engineer PWD Koithalam So, Lordship. And as the matter is the boundary dispute is there, Lordship.
Where the document doesn't say boundary dispute. From where do you read?
From the annexed by this petitioner, Lordship.
Please, you don't go by the petitioner's case. You're for the.
At this stage, Lordship, I'm praying for a notice issue, Lordship.
Yes, fully supporting the petitioner without any documents saying your documents are saying otherwise. How can you Ms. R.S. Ronghan, learned counsel for the Karbi Anglong Autonomous Council submits that he has got no instructions at this moment. Next para. Mr. P. Nayak, learned counsel for the PWD, on the other hand, submits that the termination of the contract of the petitioner was done due to stoppage of work by the petitioner unilaterally for more than 28 days and due to failure to progress, to make any progress with the work since the date of award of the work.
Accordingly terminated as per clause 59 point.
Full stop. Accordingly, his contract work was terminated in terms of clause 59.1.
59.2A.
No, 59 point. Ah,
58
aha.
for the delay card.
59 under 59.2A.
Secondly, lot of delay is
59.2A of the
this.
general conditions of contract. Full stop. Next. As can be seen, next para. I have heard the counsels for the parties. The impugned notice of termination dated 20/05/2023. States as follows, page 102. From here to here. Okay. I'm putting this. Next para, clause 59.1 and 59.2A. Capital, not small a, small a bracket. States as follows. Acha, wait, 59.1, 59.2A and clause 3.
Clause 3 of the special conditions of contract.
Clause 3 of the
Page 80.
84.
84 is the clause number 3, and the F is page 82, special conditions of contract.
No, where does it say special conditions of contract? Doesn't
Page
say
82,
82, where?
82 of F at the top block. F special conditions. of
Haha.
contract.
And
Three
clause
part-
3 and clause 3 of the special conditions of contract states as follows, Just take it up, okay? Next para. As there is an arbitration clause provided in the contract agreement between the parties, which provides for settling of disputes. This court is of the view that the said arbitration clause would have to be availed of by the parties in deciding whether the notice of termination dated 20/05/2023 was justified or not. The parties should accordingly avail of the arbitration clause provided in the contract agreement. The writ petitions accordingly disposed of.
If it is agreed not to, then we will.
Naturally, I said the parties.
I'm obliged, Lord.
Remains.
Where please, Your Lordship.
Lordship, this petition is directed against the impugn action of the respondent, whereby
It's been action of the respondent, huh?
respondent, whereby verbally ordered to close down the IMFL laptop of the petition.
Lordship, this stage, I would like to bring for matter be taken on Friday. I'll take the instruction regarding this into notice, Your Lordship. Because objections are
page-
page 50.
But then you cannot ask him to verbally close down when you have given him
That's true.
transfer.
That's true. I'm only asking for Friday's time, Your Lordship. I'll take the instruction.
Wednesday,
Friday.
Oh.
Lordship, in a similar situation, this Lordship has already
you cannot, you can,
directed to open the I'm top hearing.
why should we allow the illegal order? If you find that he's in violation of anything, then you can close it down. That's a different issue.
That's it.
Not even it should carve any notice you wrote.
No, this is different. You're right. Heard, Mister? Huh? A. Chaudhary, learned counsel for the petitioner, who submits that the petitioner is an IMFL of licensee, comma, who had applied for transfer of her license premises from Tokobari 80 Road, Guwahati to Hengarabari near Nabodaya Path, Guwahati. The district commissioner wide order dated 7/2/2024 allowed shifting of the petitioner's IMFL of license from Tokobari 80 Road, Guwahati to Hengrabari near the Hengrabari, that's what, Hengrabari, yeah. What's that? Though the petitioner has shifted her license premises and had started her business in the new location with effect from 8/2/2024. Comma. The petitioner has now been verbally told by the authorities,
Yes, respondent
by, by the respondent number,
3.
by respondent number 3, to not open her IMFL off shop. First one. Next paragraph. The petition's counsel submits that the petitioner had obtained all the necessary no objection certificates from the neighborhood residents of the license of the transferred license premise in terms of Rule 294 dash capital A and 95 of the Assam Excise Rule 2016. 16. So, he accordingly submits that there is no ground for the respondent number 3 to have verbally told the petitioner to close the shop after all the necessary formalities were completed and transfer of the license had been granted. So,
Date may flex starting on Friday, Your Lordship, against why the.
it's too far.
Then on Thursday, Your Lordship, Thursday, Wednesday.
Wednesday, just Wednesday, you just wait. Mr. R.R. Gogoi appearing for
Appearing for respondent number 1, 2, 4, and 5.
1, 2, 4, and 5. Submit that he will obtain instructions in this regard and please that the matter may be listed on
Yes.
13th.
Yes.
On 13th. List the matter on 13th.
Obliged, sir. Highly obliged.
Yes, what is your case, madam?
The registered contractor, my lord. He has completed the work, my lord, 100%. Kindly see annexure 3, my lord, page 13. Page 13, my lord. Second.
Where is the admission?
Admission, my lord, annexure 5, my lord. Page 16, my lord.
Huh?
Page 16, annexure 5, my lord. Serial number 32, my lord, kindly see, Sobiram Thaklari, 4,23,755. Then serial number 49, my lord, Sobiram Thaklari, 6,60,854, my lord.
When was this? This is regarding work order of what? Which period?
It is in the superintending engineer, Testwood, Hekias, irrigation department, my lord. And
For which period, Miss Madam?
and the work order was given in 2009-10,
And you completed when?
13, my lord.
2013?
The admitted among, my lord, they are.
I don't know. We'll issue notice.
No, she may issue notice.
Miss
As per.
Learned Counsel for the as Bora Learned Counsel for the petitioner submits that the petitioner's contractual liability amounting to rupees
10 lakhs.
10,84,609. And what about the other one also?
This is the remaining amount. Others I have got, my
What is the, you look at your prayer, you have asked for 1 lakh also, 84.
lord. That is also, my lord.
Huh? That also?
My lord, totaling 10 lakhs,
That
84,000.
10 lakhs 84,609 has not been paid for contractual works completed by her in the year 2013. Issue notice returnable in 4 weeks. Mr. N. Upadhyay accept notice on behalf of spot number 1, 2, and 3, while Mr. P. Nayak accept notice on behalf of spot number 4. This is the matter of the 4 weeks. No one appears for the petition on.
Yes, my lord. This is my lord, matter released to my non-payment of contract amount, my lord, of 1 crore, my lord. Of 1 crore, 20 lakhs, 21,000, my lord.
Why?
In this case, my lord, my contract was terminated, my lord. It was
Contract terminated when?
terminated on, my lord, at page 39, my lord.
You see, Mr. Counsel, I asked you the date, not page.
29/7/2023. 29/7/2023.
What does your contract agreement say when you have not completed the contract work?
My lord, my contract was
You see, Mr. Counsel. I think in contract agreements, there must be a clause where when you don't complete your part of the work, some others will do it, and then they get paid from there, from the remaining amount of money. So we do not know, a lot of measurements will have to be done, this will have to be done.
Yes, my lord. That was
Is there any arbitration clause?
No, my lord.
No arbitration clause?
At page 66.
No arbitration clause? Are you sure?
Yeah, page 66, my lord, can you see? Page 66. 85%, my lord, I have completed, my lord.
How much?
85% of the work.
Maybe.
So my lord, I want that, my lord, my part, my lord, which I have completed, my lord. I want that part, my lord, the amount should be paid to me, my lord.
We'll have to see, I don't know. Right. How much is that part?
Amount is, my lord.
Right, Mr. Triple S Raman, learned counsel for the petition, submits that the petitioner's road contract work had been terminated by letter dated 29/7/2023, issued by the Chief Engineer, PWD Border Roads, Assam. So he submits that the petitioner completed 85% of the contract work and that the respondents were liable to pay rupees 12,021,851 to the petition. Next para. The learned counsel for the petitioner categorically states that there is no contract agreement executed between the petitioner and the respondents for the said contract code. I hope you know what you're saying.
My lord, there is a contract agreement, but no arbitration clause, my lord.
Okay. What have I said?
That agreement is a phrase, my lord.
They submit that though there is a contract agreement executed between the parties for the contract work, comma, there is no arbitration clause in the contract agreement. Issue notice returnable in 4 weeks. Mr. P. Nayak accepts notice on behalf of all the respondents. This is the matter of the phone.
All right.
14.
Please, your lordship,
Yes,
contract matter, your non-payment of contractual bills, so your
how much is the amount?
for like 30,992,
Where is the admission?
page 28, your lord. Earlier, a repetition was filed, but it was withdrawn with liberty to file afresh.
Because,
As Union of India was not made.
okay, in that. So, Miss out here, who will be appearing? Where are the councils? That M. Burman and A. Lodha. Just call Miss A. Gayan. No, not no, A. Lodha, yes. A. Lodha was there earlier. Mrs. M. Burman was there for Miss A. Gayan. Okay, what's your name? Your name? You're the CGC? You call the other person. You call that Eloda. Actually, no, we can dispose it off, I think. Same thing. We'll put her name. Same, huh? Same thing. It's here. Yeah, it's here. Yeah, it's here already. What's her name, by the way?
Huh?
No, here's
G Regma.
Huh?
G Regma.
G. Rengma. Your name is there.
Yes, your lord.
Item number?
Item 14 here.
No, it is here. G. Rengma. Dispose that.
15.
But
Made prisoner.
Yes.
Made prisoner. Lord, the petitioner he was awarded a contract, my lord, at page 20 for 21, my lord. Construction of Gifu Medical College. Basically, the hospital complex. It is part of the entire complex, my lord, but it was something to do with the construction of the boys and girls hostel. Now, my lord, this work order was issued way back in June 2020. Then, my lord, the relevant drawings were not provided to the petitioner. Then, my lord, the site was not clear. Therefore, it took a lot of time. Eventually, my lord, if your lordship would kindly come to uh, page number 32-3, my lord. There was also an issue with regard to, my lord, estimate and all. This is a communication dated 7th of February 23. Referring to the subject cited above, it is to inform you that earlier contract value of rupees 4.22 crore, 90 lakh odd for the above mentioned work has been enhanced by 11 lakh 47,000 and odd. The modified contract value will be 4 lakh crore 34 lakhs, etc. You are therefore requested to furnish additional performance security of rupees 22 lakh thousand and odd, payable at so and so, from the date of issue of this letter, valid up to so and so, liability period of 1 year, and for signing of the modified bill of quantity, payment schedule, etc. So virtually, my lord, the contract was rewritten. In the sense, it was only on 7/2/23, my lord. The authority themselves had, modified the value of the contract. And my lord, the petitioner was asked to provide additional performance security, etc. Then, my lord, at page 34, the petitioner submitted the additional performance security of 22 lakhs. Then at page 35, my lord, the revised drawings were provided to the petitioner. Now, my lord will kindly appreciate one thing. Earlier, the building was for construction of G+2. Now, as per the modified order, it is G+1. That means, my lord, all throughout my point which were agitating, it had substance. In fact, they themselves said, now it will be G+1 instead of G+2. For example, if your lordship would kindly come to page number 21 for a moment, my lord. Page 21, this subject is the work order. Construction of girls hostel G+2. Am I clear, my lord? Then please come to page 35. The subject, construction of girls hostel G+1.
But
my lord.
why is it become costlier when you're going to cut away one floor?
No, my lord, even then, now I'll show, that is my case. Now, your lordship, after paying it, then my lord, at page 38, I wrote this letter when I was asked to commence work. Then at page 37, before that, my lord. That with reference to the above, it was on May 23, that with reference to the above, I have the honor to inform you that though the modified work order for the above mentioned work was issued to me, but later under reference dated 10/3/23, yet construction site was not vacated by the other contractor, whereas dump construction materials like coarse aggregate, shuttering, etc. at my construction site, necessary evidence of dumping of material at the construction site are included. In fact, these photographs are there, my friend. In view of above, you are requested to take urgent necessary steps to vacate the construction site to enable me to start the work at the earliest. This is my request. Then, my lord, I wrote to the mission director. This is where my shoe pinches now. Now, after the work was modified, please come to the subpara. This time also, I engaged my technical staff to evaluate the cost as well as other technical aspects based on the modified drawing and design of the project as per APW schedule of rate 1314. During evaluation of only 10 number of items of civil work, that is pile work, earthwork, anti-termite treatment, PCC work, RCC work, shuttering, steel reinforcement, brickwork, plastering, floor, wall tiles, etc. A huge difference in financial involvement in comparison to modified tender value comes out, which are as follows. Total amount for this 10 item is 5.86 crores. then there is an element of rebate. Kindly see, my lord, amount required to complete the work of these items is 5 crore 51 lakhs. Modified contract value is 4.34 lakhs, and the cost difference is 1 crore 70 lakhs. My lord, there are more than 150 items. In 10 items only, I'm supposed to incur a loss of, my lord, 1 crore 17,000.
No,
Now,
should we go into all these
No, no,
issues?
yes, yes. Now question is, my lord, possible kindly have the contract text.
First of all, is there any arbitration clause
No, my
between?
lord, the problem is they have not provided me the agreement itself. That I have stated. If your lordship would kindly come to page 5, para 5, page 5,
Page
the last sub-para, my lord.
This,
What he to mention that copy of the agreement of the work executed between petitioner and the respondent has been retained by the respondent till then. For which reason, same could not be annexed here. I don't even know, my lord, what does it contain.
let them produce.
No, no, my lord, I have a small point. My lord, merely because, supposing, my lord, there is an arbitration clause. My lord, all that we are saying is, I am saying that the bill of quantity which is provided in the contract, it's not commensurate with the estimate. So what I have prayed for is, my lord, either Assam Engineering College or IIT should be asked to find out whether I'm right or wrong. That they're why they are feeling silent. I'm not asking for anything. My lord will kindly appreciate under section 54 of the Contract Act, I am not bound to perform this work if they do not perform the reciprocal part.
Let us see the contract agreement first.
Okay, lordship will have that. Also, lordship will kindly, in the meantime, ask them to have the estimate
No,
verified by the IIT Guwahati or Assam Engineering College.
Let's,
So, my lord, it is very easy to relegate us to the arbitrator. Why should we go to the arbitrator when our remedy is 226 court?
no.
No, no, my lord,
There are technical aspects of
that's
it.
why I say.
How do
No,
we
no,
know?
then, my lord, who is this, my lord, mission director to know all these things?
Let us
Can you see,
let us
can you
see,
see the
let us see.
termination order? Impugn termination order is issued by an IS officer. He is also not expert. So
Yeah.
therefore, has he taken the views of the technical expert?
So let us see that.
No, therefore, my submission is, my lord.
Yeah,
lordship, do
where is
not
the-
relegate us
where
to
is the-
arbitration
where-
like a routine matter.
where is the
It all
termination?
depends upon facts of each case. The impugn termination order is at page 50. This lady who has signed it, she is not a technical expert. Has she taken the views of the expert regarding my lord, my grievances? Earlier, my grievance stands, my lord, proved because they brought down the quantity and it was made from 2 floor to 1 floor. Statement is,
Right, Mr. K. Chaudhary, Learned Senior Counsel for the petitioner, who submits that the termination order dated '22 to 2024 issued by the mission director NHM Assam should be set aside. Good, sir. Yes, you are appearing for
Lordship, B Gogoi, Lordship,
Mr. B. Gogoi,
for NHM.
appearing for the NHM, shall produce the contract agreement executed between the parties. List the matter. When can you bring?
3 weeks time, Lord.
Right, 3 weeks. There's the contract agreement, bring it.
Lordship.
Next week, next week.
We'll try that.
This is the matter on Monday, next.
Only thing is, my lord, they have terminated my contract. Only thing is, they should not, my lord, encase the bank. It is with them. Let's not encase it. That's my only play. Now, my lord, my matter is very simple.
We'll take it up next week, Monday.
No, my lord, let status quo be maintained regarding, my lord, encashment of the bank. It is with them.
Let me see now.
Yes.
No, I don't know.
And my interim prayer is there, my lord.
I don't know whether we should interfere here.
No, I'll satisfy your lordship, my lord. In an appropriate case, certainly, lord. Otherwise, my lord, this 226 remedy makes no sense.
No, but out here, there's a lot of technical issues.
So
with
that's
it.
why I said, all that I'm saying is, my lord, the amount of work they want me to do in terms of the money, it is not possible. I'm also a very reputed contractor. I've got so many contracts. Whenever, my lord, we have verified. That's why I'm saying, my lord. All that I'm saying is, let the view of the IIT Guwahati or Assam Engineering College be taken, whether the bill of quantity is commensurate with the BOQ. That's all. If they say yes, I'll be out. An independent body is, my lord. Because this mission director is an IS officer. How can he have this expertise, my lord? If they can show that while preparing the estimates, they've taken the views of the expert, then also, my lord, it's always better to have an expert view. Only thing is, my lord, they will not encase it, my lord. They will retain it. They have already retaining it. Till the next day.
Okay, right. Till the next date, the bank guarantee shall not be
Deep-
encashed. Only the bank guarantee,
That's-
only till the next date. You get it by Monday.
Okay.
We'll dispose everything off.
Lordship, if possible, can extra copies be also given to us?
Yes, extra copies of the writ petition, please provide.
May it please your lordship. This is a matter wherein with relation to retail outlet of the IOC, your lordship, allotment of retail outlet. The petitioner was the selected person, but ultimately, if there were different groups, I'll come to that. Out of that group, he was selected in group 1. But ultimately then, after the some documents were required, after those documents were provided, he was put to group. Only that.
What is this? Retail outlet.
Retail outlet, your lordship.
Yes,
Under the IOC, your lordship.
Yeah.
What has happened? I'll just point out the advertisement that your lordship will find at page 19. I'll not go into, there is no dispute. I'll come directly into the dispute. So there was on 28th of June, 2023, an advertisement was issued. And we are at the website advertisement. Our serial number is 94, your lordship. Then your lordship will kindly straight away turn to page, I have applied. And page 32 from here, page 32. This is the letter issued to me. This is the location is 3 kilometers from Laholial Chariali to Gongalmara Road. This is the location. It's in Lakhimpur district, and the category is Sidal tribe category. I have applied
Yeah,
under the
so
Sidal tribe.
you're provisionally selected.
I am provisionally selected by December 7th. Then what has happened, your lordship? In the next page, page 33, I was directed to deposit the initial security deposit. So that was on 18th of December. Then I deposited on the next page. I have deposited that on 22nd of December, the amount required. Now, your lordship, page 7. Oh, sorry, page 35, annexure 7. This is where the matter starts. I'll just read that. Page 35, annexure 7.
Yes.
The initial deposit I have made. Now, this was issued to me on 20th of January, 2024. Lordship, I'll just read this. You are requested to upload the following rectified, corrected documents, to upload so and so documents, so that your application for award of retail outlet dealership at the above location can be processed further. These are the documents which they require. Notarized affidavit by the applicant as per so and so. Khasara, Khatoni, and other relevant revenue document or certified obtained from revenue official confirming status of ownership of the land as on the date of application. This point is the actual point. Then copy of other documents regarding ownership, sketch and offered land with dimension. Reasons have been given. Name of the deponent in appendix so is not correct as per the application. All the applicable clauses so and so are to be filled and submitted. name of the applicant in graduation certificate from Dibrugarh University is so and so, and mention in the applicant as so and so. Applicant to clarify the correct name in the form of an affidavit. As per the Jamabandi submitted, the offered plot of land is muted. This is the point you make. Mutated and jointly owned by Mr. Sri so and so, the petitioner, Sri Mohan Deori, late Prince Singh Deori, and late Kanakanta Deori. But appendix 3 of only one co-owner, Sri Mohan Deori, is submitted. This is important, your lordship. The name, there are 4 names in the Jamabandi. Out of the 4, only one was submitted. I am the petitioner. The other 2 are late persons. Dead persons. Appendix, the co-owner, so and so, are to be submitted. Shareholding of applicant, shareholding is not required, your lordship, because I am already in the group 1 criteria. So I have to submit this. Then from page 36 onwards, these are all documents which are submitted prior to that. First is the affidavits have been submitted. I will specifically show the affidavit where the other Pattadar has given his consent, that at page 41. The only issue is that page 41, your lordship will kindly turn.
Page 41.
41. This is the affidavit of the joint Pattadar.
Yes.
So this was submitted at the time of application itself. So this is accepted. Now they wanted that all the co-owners have to submit. Now the other 2 co-owners are dead persons. There are 4 persons.
Page 41 is, what is this?
This is the
Affidavit.
affidavit filed by the co-owner of the particular land use.
No, what is your name? Your name
My name
is
is Jagneshwar Deori.
Jagneswar
This is
Dev.
my cousin brother Mohan Deori. So there are 4 persons, Mohan Deori, Jagneshwar Deori, my father, and the father of Mohan Deori are the co-pattadars in that particular plot of land
Okay.
of the 10 bighas. My father and the Mohan Deori's father has already expired. So I have given the, your lordship, the affidavit of the co-pattadar, joint pattadar, Mohan Deori, saying that there is no objection on his part. So that was submitted at that point of time. But they say the other co-partner's name has to be given. How am I supposed to give the dead person to your lordship in the affidavit? This is where they went wrong. I'll come to the order. Then I have submitted all the other documents regarding, your lordship, there was a document regarding the name. With regard to the name, that also I have submitted, Jagneshwar Deori, that your lordship will see at page 47. They wanted me that my name, correct name should be given on an affidavit. It was given, page 47. Jaganeshwar and Jagneshwar. This is corrected. Now, your lordship, what has happened? Lordship will kindly turn up to page 49. One thing I am just pointing out. This is a subsequent document given, page 49. What has happened, your lordship? The plot of land, where I have the location for the IO I have given, or RO I have given, that plot of land has been mutated in my name. I have partitioned the land of 10 bighas. From that 1 bigha, which is required for the petrol pump, that was mutated in my name, and I have given the affidavit of that also. That is page 49. Now, your lordship will kindly turn to the page 50. This is where the whole thing happened, your lordship. Page 50.
Yes.
This is the Jamabandi copy, translated copy. The original is also there.
Yes.
Here, your lordship will see Pattadar name, Balaram Deori, Jogeshwar Deori. This is the petitioner. Mohan Deori, late Param Singh Deori, and late Ghanakanta Deori. Now, your lordship, Jogeshwar Deori and Mohan Deori are alike. Balaram Deori is a late person. Param Singh Deori is already shown as late. Ghanakanta Deori are late. So these are the 5 persons who were there in the Jamabandi, and your lordship will kindly read the remarks part. I'll read that. As per the order of the circle officer dated 4/12/2021, much prior, mutation has been done against inherit plot of land covered by Dag number so and so in favor of Jogeshwar Deori, the petitioner, and Mohan Deori, son of Balaram Deori, registration number so and so, so and so, so and so. This is the second part, is also the order under the order of the lot mandal. This is lot mandal. So the land has been mutated in both me and Mohan Deori's name. Our father, both our father and my uncle are not alive. So how am I supposed to give the annexure affidavit as annexure in the application, your lordship? So that is clear. And now one more thing I would like to point out is that at page 54, one more thing, Your Lordship. The earlier is 10 bighas, Your Lordship. 10 bighas of it.
Yes.
This is, page 54 is the latest Jamabandi, that is recent Jamabandi of 29/1/24. Here, Jogeshwar Deuri, the petitioner, in his name, 1 bigha of land has already been mutated.
Where do you get that 1 bigha?
This is, Your Lordship will find the column 5,
Ah, okay,
1 bigha, 0 katha, 0 less.
okay.
So these are already there. Now Your Lordship will kindly see, after submission of all these, I have also submitted at page 61 is the sample site map which was required, that was also submitted. On all the record is there. Page 62 is the trace map that is also submitted. Everything is there. Now Your Lordship, the impugn order at page 64. Kindly see the impugn order. Page 64, this is of 10th of February 24.
Yes.
Page 65 it starts. Please refer to application number so and so on the subject. Please also refer to our letter dated 20 January 2024, wherein you were advised to submit certain documents, corrected documents regarding your offered land. However, we have not received the required documents from you within the stipulated time as detailed below. These documents they have stated that they have not received within the stipulated time. Though offered land is mutated in the name of the applicant on so and so as per the Jamabandi submitted, however, as on date of application, offered land was jointly mutated in the name of Mohan Deuri, late Prem Singh Deuri, late Ghanakanta Deuri, along with the applicant. Appendix 3 from the co-owners, Sri Mohan Deuri, legal heir of late Prem Singh Deuri and late Ghanakanta Deuri is not submitted. Documents not found. Okay. Now, this is not correct. I have submitted Sri Mohan Deuri, the legal heir of Prem Singh Deuri, who is a co-pattadar of the said land. His objection is there. Now, shareholding document as on date of application is not submitted. Jamabandi after the mutation of the offered land on so and so is submitted, which is not. So otherwise, there is no issue at all. All the documents are there. They have stated that the mutated land of 1 bigha in my name was done after. Fine. But the overall land that I have submitted at that point of time, Mohan Deuri has given his affidavit to Your Lordship and he has only asked, these are the documents you have to provide. I provided. Now, where is the question of giving him at that point of time before asking you? Now, Your Lordship, then the next page, Your Lordship will kindly turn to the next page. Sorry, the same page I will read the para 4. In view of the above, we regret to inform you that your candidature has been found ineligible. However, your candidature may be considered for selection along with group 3 applicants as per guideline. That your candidature has been found eligible. However, your candidature may be considered for selection along with group 3 applicants as per guidelines. In case, this is the part, Your Lordship, you have any grievance against the rejection of your candidature, as mentioned above, you may make your representation by 20th February 2024. Now, on 19th of February, next page, page 67, I made the application. Here I have specifically stated, Your Lordship, at the second and third paragraph, that, sir, at the time of my initial application, appendix 3 of Mohan Deuri was already submitted. So at that time of application, I have already submitted this document. Where is the question of Your Lordship not submitting the document at the relevant point of time? Then again, I have submitted, when he asked that you submit your name verification, these documents, all I have submitted. With regard to the documents of my father and my uncle, those are dead person. How am I supposed to sign an affidavit on their name? So that is the reason. And now I have given the application. This was given. Now I have come to know that they are planning to give it to somebody else.
Yes.
They have not yet disposed of this application. At annexure page 67.
67 is the representation he has submitted. And this is yet to be disposed of. Perhaps Your Lordship may direct that this can be disposed of, giving him a personal hearing, because my lord, many facts my learned friend has been saying. Maybe my lord, he may have a case.
It appears he has a case.
Yes, my lord,
It appears he has a case.
have a personal hearing.
Until then, nothing should be done. Nothing should be given.
That is agreeable.
Because I think maybe they did not think,
Yes.
enough. Maybe Maybe they need some personal hearing, then they'll understand maybe.
Yes, ma'am. That's why I say that let it be disposed of after giving him a personal hearing, so that he can try to conduct it.
Heard Mr. Y.S. Manat, the counsel for the petitioner, who submits that the retail outlet dealership within 3 kilometers from Laholial Chariali, Bongal Mara Road, in the district of Lakhimpur, Assam, under ST category pursuant to advertisement dated 28/6/2023, was provisionally, no, the was provisionally
Provisionally selected.
no, no, who submits that the petitioner in respect of the retail outlet dealership was provisionally selected. Full stop. The IOCL thereafter, by letter dated 18/12/2023, requested the petitioner to remit the initial security deposit amount and upload specific documents. Full stop. The same was done by the petitioner.
The documents at page 35, which were required, page 36. By letter dated 20 January 24. Page 35.
The petitioner's case is that the petitioner had submitted the 10 bigha plot of land in which the petitioner and his cousin, what is his name?
Mohan Deori.
Mohan Deori, were co-patadars. The other co-patadars were the father of the petitioner and the father of Mohan Deori, who had expired. First up.
The grandfather's name was also there, who is also not there, expired.
First up. Further, the grandfather of the petition had also expired. He submits that. The petitioner's counsel submits that. Besides the above document being furnished to the IOCL, the petitioner had also made a separate Jamabandi for 1 bigha of land in the name of the petitioner, which he had submitted separately. He accordingly submits that there was no ground for the respondent authorities to have declared the petitioner ineligible for being allotted the retail outlet dealership when all the documents were in order. All the documents submitted by the petitioner were in order. Full stop. The petition, next para, the petitioner's counsel submits that pursuant to the impugned, where is that impugned letter?
This is actually, this is on page 64,
Impugned letter,
dated 10 February.
impugned letter dated 10/2/2024, issued by the IOCL, the petitioner made a representation dated 20,
No, 19.
made a representation dated 19/2/2024
Was received
the-
on that days.
to the divisional retail head of our Tinsukia Divisional Office, Assam, which has not been decided till date. Pusta. The petitioner's counsel submits that though the respondent authorities have not taken a decision on the petitioner's representation till date, they are processing, they are making attempts to award the retail outlet to some other person. Pusta. He accordingly submits that the said retail outlet should not be allotted to another person till the petitioner's representation dated 19/2/2024 is decided. And by decided, besides giving an opportunity of hearing to the petitioner in person prior to the decision to be made. Pusta. Next, Mr. M.K. Chowdhury, the learned senior counsel appearing for the IOCL, submits that the petitioner will be given an opportunity of being heard prior to deciding the petitioner's representation dated 19/2/2024. Pusta. Next, in view of the consent of the parties, the respondent number
Number 2.
the respondent number
3, divisional head, 3.
is directed to decide the petitioner's representation dated 19/2/2024. Mustafa, however, before taking a decision on the said representation, the petitioner should be given a personal hearing by the authority concerned. Mustafa, till a decision is taken by the respondent authorities, the said retail outlet should not be allotted to any other person.
Well, perhaps we can be a little more specific, because next step is holding of draw among the other candidates. So that draw should not be held. That should be, I think that would be more helpful for him.
Okay, so a new draw will be held.
Yes.
Okay, so what have I said?
May not process, I think that will be a better.
May not process.
Okay, may not process. What have I said? Should not be processed for allotment to any other person.
Whatever process they,
Yes,
much.
that is petitions accordingly disposed of.
Made reasonable. This is the last order, your lordship, can you see, my contact was cancelled, my lord, I am challenging that.
Yes, you are supposed to submit.
Your lordship, my lord, in annexure 5, my lord, that letter dated 13/12/23, I have received, my lord. Others are, my lord, I have not received. Others have not furnished to me, my lord. Others, your lordship, kindly see, first one is, my lord, my preliminary work order. But other 2, 3, 4, 5 in annexure 6, my lord, that was, my lord, as per my instruction, my lord, my client doesn't get receive it.
Huh?
My not receive it.
I don't know, then you'll have to produce. Yes.
No, let them file a affidavit on that, my lord. Your lordship kindly see that letter I have received, my lord. That's it. And that too, my lord, send in the WhatsApp, my lord. My,
That we don't know. That is
no,
that is your submission.
no. If they have submitted, my lord, then let them file an affidavit. My submission before your lordship that during my tenure, 6-month period is yet to be over. 6-month period, my lord. Your lordship kindly see without they said that, my lord, we gear up.
Out here also notice is given. Otherwise, work order will be cancelled without further notice.
That, my lord, they cannot, my lord, your lordship, they asked me to, my lord, gear up. My lord, when they moved, they have done it, my lord, because now person respond number 7 has been allotted the preliminary work without any, my lord, tender. That cannot be done, my lord. So there, my lord, intention, your lordship kindly see, my period will be over 31st March, my lord. So how they can, my lord, in the month of January, my lord, they can, my lord, issue cancel my.
You see, because usually in this road contract works, I don't know if it's
No,
here
my lord.
also.
This is, my lord, not road content, my lord, this is, my lord, water supply.
What is the?
Jal Jeevan Mission.
Okay.
So only, my lord, lying of the pipeline is now, my lord, other construction has been done. So other construction, my lord, there are 4 part, my lord, and 3 part already I am completed, my lord. Now, my lord, only the pipeline, installation of pipeline is, my lord, left out. But my lord, my learned friend said that, my lord, 6 months, you lord, kindly see my final order, my lord, formal work order, my lord, that is page 33, my lord. Page 33. Formal work order. The other man not yet started because he is already receiving the preliminary work order. That was, my lord, without any.
Yes, what to do, Mr. Nayak? Yes, put it off. I'm having the cold. Put on the AC.
My lord, I think he was.
No, I've been
Something
having
cold.
this since last week.
Yes, that is.
Lordship, this is a case report dated 26/7/2023.
Yes,
And at page 21, Lordship will see the preliminary work order. Page 21, 12/5/2023.
yes,
So work has been started immediately after the preliminary work order was issued. So
yes.
that is why even before the final work order is issued, one test report was there. Lordship, in this test report, Lordship will see at serial number 2. These are the deficiencies, serial number 2 and 6. Then Lordship will come to the
Just
next.
a minute, result 59. Desirable limit 500, maximum 2000.
Next page is more elaborate, Lordship. It's 29/9/2023. Next page of that branch, Lordship. That branch itself.
There is no pagination out here.
Next page, Lordship. Next page, yes, it is dated 29/9/2023. Government of Assam, Office of the Executive Engineer, PHE, Gusaigaon Division. I'm sorry, Lordship, it does not paginate.
Dated?
Dated 17/11/2023.
Yes.
This is another notice, Lordship. It has been alleged by the Assistant Executive Engineer Gusaigaon Subdivision by this letter under reference that you have not paid any attention to the repeated request from the section officer, PHE concerned, to maintain the quality of construction and arrange to supply the requisite quantity of materials. Please note that the matter has been viewed seriously and you are requested to rectify the defective work, if any, in consultation with the Assistant Executive Engineer, PHE, Gusaigaon Subdivision, and Section Officer, PHE concerned. Furthermore, it is really very disappointing that your performance is not as per time, terms and conditions of JJM, and hence you are requested to expedite the progress of the work to complete the work within the stipulated time frame. Please note that willful delay from your end to expedite the progress of work at this crucial time to complete the work may invite serious consequences, as the undersigned will then have no other option than to arrange for imposing penalty or cancellation of the order. Next page, Lordship will say this is 30/11/2023. Quality inspection report.
Yes.
17/11, Lordship, that second notice was issued. Then now it is date of first inspection 30/11/2023, second inspection 4/1/2024. Lordship will see the third column.
Yes.
Problem found during inspection. Serial number 1, river aggregate is used instead of truss aggregate. 2, ESR foundation constructed without the construction of PHE, without the concern of PHED. Third, the third class brick is mixed. Then in the next page, Lordship, another inspection, Lordship, it is dated 30/11/2023. Durgapur bar is used at site, which is not in as per specification. Next, Lordship, river gravel is used instead of cross lever. Third page also said third class brick used. Next page, Lordship, one letter dated 4/12/2023. Lordship, this is the recommendation by the executive engineer PHE. Lordship will see the last paragraph. Under the above circumstances, I would like to recommend the cancellation of the work immediately and engagement of other suitable agency to complete the work at the earliest. Next page, Lordship, 18.1. The contract was cancelled. Lordship. Now, so far as work value is concerned, Lordship, two documents your Lordship will take note of. One at page 33. Page 33.
Repetition.
Page 33 of the repetition, Lordship.
Yes.
In the middle portion, Lordship,
Yes.
approximate value of our work,
1 crore.
1,69,25,78. Lordship, in the terms and conditions, in the first condition, Lordship will, it is 6 months. Then in the subsequent work order, Lordship, page 45.
40?
5. Lordship, this is the balance work. Page 45. Approximate total value offered 68 lakhs 42,34384. So this is the amount for the balance work. Lordship, this work has all petitioner, this subsequent contractor has already started his work.
No, my lord, no formal order has been issued, my lord, till
So
now.
even he has
No,
started
my
the
lord,
work.
that is
even
without any
without
tender, my
formal
lord,
work
without any,
order.
that is the Mela Faidi, my lord, without any tender, my lord. How they can do?
That is a
Your lordship
that is the
kindly
issue
see,
of
these are the documents not supplied to me, my lord. These are documents which are, my lord, for cancellation.
But
they have-
you have not been doing the work properly.
No, my lord, your lordship kindly, that is their, my lord, their comment, my lord, that is not even.
Naturally,
Let
naturally.
them file that affidavit, my lord. Your lordship kindly see one.
Okay, we'll issue notice, let them file
Your
affidavit.
lordship kindly page
No
33,
stay, but-
page 33, kindly see, my lord. I'll just show one thing, my lord. Page 33, my lord. Page 33. So, terms and conditions, very fast terms, my lord. Your lordship kindly see. Very
Yes.
fast time. The offered work should be commenced in consultation with the executive engineer PSC Gosaigaon division and should be commenced completed within 6 months from the date of issues of this order. So that order was issued, my lord, on your lordship kindly see,
28/9.
my lord. So my lord, it will be my lord over by 31st of March. My lord, in January they have cancelled it, my lord.
But you are using third class material, no?
No, my lord. Your lordship, I have given a
Lordship,
reply, my lord,
first
because
test
we have to,
report is of
that is, your lordship
26/7.
kindly see my
Huh?
reply.
First test report.
That
is of
has to be, my lord, joint
26/7.
verification has to be done, my lord. That is not been done.
Lordship, work was started immediately after the preliminary work order. That is why test report was there of
No,
26/7.
test report is, my lord, prior to it. That is different, my lord. Test report, your lordship kindly see prior to commencement of the contract, my lord. The test of the
What
soil,
is
my
the,
lord.
where is that date, that 28/9 page?
My lord.
That
That is,
28/9?
my lord, annex 4, my lord, page 33. Page 33. Page
Yes,
30.
one thing, page 33, just come to page
Yes,
33.
Lordship. That is the final work order.
So from that order, it will be started.
Formal work order, no final work, formal work order.
Formal
Formal,
work.
till it is started
So
from
it's
formal
not
work.
even final, it was formal. So preliminary work order was already there at page 21.
No, my lord, it will start from formal work order, my lord.
That is the 12/5, Lords. 12/5/2020.
No, my lord. Of your lordship kindly see the language, my lord, of this order.
Lordship, a work order is work order, Lordship. Only the formal work order was issued subsequent.
Aha, okay, okay.
In formal work order, they have stated from this 6 months from this order. The month from that, this issue of this order.
It
This
will
order
come
means
from-
final
But it
order.
says they come to term and condition number 1.
Yes, that I have seen. That is right. Lordship. If that is the formal work order, and if you are not supposed to start your work prior to that, Lordship, then how this state test report dated
This report
26/7,
not included in this.
26/7/2023, Lordship?
Okay, according to you, when did you start your work?
After this, my lord, no, this, your,
No, I'm asking you a question.
without getting formal work order, we cannot start work, my lord.
Hmm.
Because, my lord, in preliminary work order, my lord, suppose that site is not suitable, then they will give it up. So formal work order will be started from the date of issuance of the formal work order. So they have issued formal work order on 28/9/2020, and 6 month period is already clearly mentioned from this order.
Just call the. Yeah, just for 5. Where is the preliminary work order?
Preliminary work order, my lord, that I have annexed.
21.
Page 21. Is the technical order.
Okay. Right. Heard Mr. T.J. Mahanta, learned senior counsel for the petitioner, who submits that the petitioner's contract work has been terminated by letter dated 18/1/2024 without issuing any notice to the petition. Thus, the further preliminary work order has been issued to the respondent number 7 without any tender being issued. He submits. When the petitioner's case is that the formal work order was issued on 28/9/23. Bracket page 33, yeah? And the same was to be completed within 6 months from the date of issue of the of the formal work order. However, prior to 6 months being completed, the contract has been terminated due to non-compliance to expedite the pace of the work. Pace of the work, as well as use of unspecified materials for construction purposes. Next part. Issue notice, returnable in 2 weeks. Mr. P. Nayak accept notice on behalf of 3 weeks,
4, 5, and 6.
4, 5, and 6. Who is 1, 2, 3?
HE department also.
1, 2, 3, my lord, the state of Assam, my lord, the mission director, Jal Jeevan Mission, the government, my lord, take.
Petitioner takes step for service of notice upon the respondent number 7 by registered post with AD within the course of the day.
On private responsibility.
There is a private assignment, I am challenging him.
Okay, next, right, Mr. P. Nayak has submitted
Agree to me, এটা to PHA sending not to
documents which show that, which appear to show that, which show that materials used by the petition are not up to standard materials. On considering all the above, this court is of the view that an affidavit should be submitted by the respondents.
substandard material and delay lordship. That has been admitted by the petitioner himself at page number 36.
No, but the thing is that according to him, that 3 months, 6 months will end only this month. 6 months will end only on 28th of this month. In the interim, the impugned Preliminary work order dated 8/2/24. Issued to the respondent number 7. Shall be kept in abeyance.
If the work has not already been started.
Comma, if the work has, if the work has not started.
Already. Yes.
My lord,
If the work has not started, huh?
if you
Item?
17.
These are eviction matters, my lord.
Lordship, I most humbly submit. In this matter, they have filed one additional affidavit. Many times we have asked a copy of that so that we can file the reply. They have not provided. Yesterday, only 8 p.m. night, my colleague's mobile is provided incomplete. So kindly give me that copy, Lordship, only I will reply. And
Court
any
records,
your
my lord.
lordships, any
If I have not served, how could I file it, my lord?
Lordship,
Yesterday, I have served an extra copy. If I did not serve it, how could I file it before
last
the
2
registry,
weeks
my
we are
lord?
asking Lordship copy. Last 2
What
weeks.
is your case?
This is an eviction
No,
matter. my lord.
Lordship, my case is we are challenging the perversity of the impugned judgment of district judge passed on 6/11/2007.
Where is that judgment?
That is Annex 18. Lordship.
Annexure 18 of the writ petition,
Yes, Lordship.
page, just a minute. Is this book form,
Yes, sir.
page
Yes, 308 is starting from the
308? Miscellaneous civil appeal.
Lordship.
This is arising out of what?
The eviction orders issued
We have
the
challenged the eviction order, Lordship, issued by the respondent.
Eviction orders issued by the,
Railway.
by the railway authorities. That is the thing, my lord. This is not maintainable at all because the eviction orders are not under challenge and the persons who are aggrieved by the eviction orders, they are not before this honorable court as well as they were not before the honorable district judge. This is not maintainable at all, my lord. Who can file a suit or proceeding, my lord? It's the aggrieved party. The petitioner herein is totally alien to the proceeding, my lord.
Is
It's a
totally,
Paragraph 7.
totally alien to the proceeding, my lord. It's a cooperative society and the eviction orders and the eviction cases were instituted by the railways against individuals, my lord. They are not before this honorable court and they were not before the honorable district judge, and on that count only, the appeal was dismissed. This
Yes.
is the preliminary issue, my lord.
Lordship, kindly
If
see
that is
paragraph
decided, my
7,
lord,
Lordship. Paragraph 7 will clearly.
just a minute.
section
Let us go to the eviction orders.
it starts from page 135 onwards, my lord.
Page
135 onwards. These are all individual orders and individual eviction cases
page 135.
onwards.
Same date,
Same date, my lord. And even
All identical letters, Lordship. All identical.
eviction orders dated 2/8/2012.
from all the orders,
It's up till which page?
all the orders are not annexed, my lord. Only a portion of the eviction orders are annexed.
Uh-huh.
165.
Till 165.
There were 78 or 79 eviction orders, my lord. Only a few of them.
So now, so these eviction orders were issued. Then who went to the
My lord,
district court?
thereafter, they approached this honorable court by way of a writ petition challenging this
These
same
eviction
society-
orders.
eviction order. Now,
Where is the order of this court?
order of this court, my lord, is found that page.
Page Lordship 156,
156.
Annex 9.
They were relegated to the
report of the honorable district judge, my lord. Since
156. Okay. So the district judge is the appellate authority.
is the appellate authority under section 9 of the Public Premises Eviction of Unauthorized Occupants Act 1971. Now, before the district judge, none of the persons against whom the orders were issued were parties.
No, Lordship, they were party. I will
My lord,
submit. it.
lordship will come to the first title of the appeal, my lord. It's already there.
So the judgment will reflect Lordship, as we said. What is the perversity and what is the bias? Total procedural error, Lordship, gross procedural error.
That's a different issue, my lord. You first of
That is the
all,
main
you
issue, sir.
have to overcome the issue of maintainability of
Good.
the
As per their
Let us see that.
just appeal, ma'am. Just a moment. It starts at page 166, my lord.
166.
What you will see, kindly see the
Lordship, I
First time.
wrote judgment 308 starts from page 308. And what is perversity, Lordship, I would like to show there. In the paragraph 7, Lordship.
well, the issue of maintainability has to be overcome, my lord. This is the cost title. The appellant, my lord, is Bokajan Sarvajani Kalibari Committee, a society registered under the
Lordship,
Societies Registration Act, my lord.
Lordship, may kindly take
This
the para
society
7,
is
Lordship.
totally
Only-
alien to the proceeding.
Only para 7, Lordship.
No,
Just a minute, just a minute.
no notice, nothing was issued to this society. These were all individuals who are unauthorizedly occupying the railway property against whom the eviction orders were issued. Now, if they were agreed by the eviction order, they were supposed to file individual appeals before the Honorable District Judge, my lord, under section 9 of the Act, my lord. Having not done that, my lord, the Honorable District Judge has rightly decided the proceeding, my lord. And even before this Honorable Court, these persons, these agreed persons are not parties, my lord. Even in this petition, my lord, Lordship may kindly peruse the cost that
Just a minute.
it's a settled position of law, my lord, on
Page.
in this petition, my lord.
Yeah.
Page 4 of the writ petition.
No, I'm talking about where's the judgment of the
Judgment of
District
the
Court.
district judge starts from page
308, Lordship.
308.
308, page number.
Forget
The
about my lord.
relevant portion, Lordship,
Being
para
party-
7 is the para 7, para 11, and para 12. Here is the perversity, Lordship. Apparent perversity, Lordship. Para 7, Lordship, may I read?
Just a minute, just a minute. Yes,
Now, Lordship, as per the learned appellate authority, there was no document we submitted and no document as regard to the Bogajan Surveillance Kalibari Committee. But Lordship may kindly come to page, Lordship, page 183, Lordship. Here is a order passed by the then appellate authority, that is the deputy commissioner earlier. Page 183.
yes.
This is the order showing that we have submitted document, Lordship. One eighty-three, appellant Bimal Sil present with the learned advocate so and so. He received documents in connection of the instant case, copy of which provided to respondent to learned advocate being appeared today. We have provided all the copy records.
Page 183.
183, Lordship.
Yes.
This is the order from the court itself.
What does it say?
Say that we have submitted the document, Lordship, relevant document of the case.
What does it mean?
Would it make them a party in the?
That doesn't, that
Again, we have some, from 185 onwards, we have.
does not say anything. Submitted what? History of document. What is history of document?
It was filed by.
What is this document?
Additional document, but the court said that you just make it correct and you write here prescribed document. As per the court direction, we have submitted. Anyway, Lordship, we have submitted all the documents while they are saying that don't document on records as para 12.
The thing is, my
The
lord,
main thing, Lordship, we are challenging the notice, Lordship. Notice doesn't meet the mandatory provision of the law, Lordship. And that one we have challenged, that number of judgment are there, Lordship. I have also done that.
What?
So, notice
Notice?
should specifically describe the premises, dark number, patta number, and the land which sought to be evicted.
Okay, tell me one thing. Is it your property?
No, Lordship. It's not even the railway has ascertained their property. Lordship.
admitted fact, my lord.
No,
On
Lord,
records,
we are not admitting railway land.
Also
And,
from
and
records,
Lordship,
my lord,
kindly
that
allow
is-
us time to file the additional.
Just a
that
minute.
is-
You
affidavit.
sit down. If you're not prepared, you just sit down.
It's been 7 years, my lord. A stay order has been operating in the case and the sanctioned projects of the railways have got stalled. My lord, these are projects of public importance, my lord. One of the project is, my lord, construction of a road and a bridge over the level crossing, my lord. The public in that area is hugely suffering. Now, I'll show from the records, my lord, where it is admitted that this parcel of land is a railway land. This was the writ petition in connection to which, my lord, the earlier order of this honorable court was passed, my lord. The writ petition, lordship will find, my lord, it starts from page 251 onwards. The relevant portions, my lord, where it has been admitted, page, paragraph 6 onwards, my lord, 256. In several paragraphs, it is an admitted position, my lord, that it's a railway land. And they have even admitted that they are paying leases and taxes to the railways, my lord. May I read out, my lord? Page 256 onwards.
Yes.
The petitioner begs to state that the railway authority of the NF Railway, Bokajan, authorized the members of the petitioner society by giving lease to start business upon the railway land at Bokajan for earning livelihood. This is the first admission, my lord. Thereafter, the
Yes.
next paragraph, my lord, that the petitioner begs to state that most of the members of the petitioner society are married men having wife and children who are solely dependent on the income. Thereafter, my lord, paragraph 8, the petitioner begs to state that the members of the aforesaid society have been running their business by doing stationery so and so, earning their livelihood, paying taxes regularly to the railway authority, town committee, so and so. Next paragraph also, my lord. In several paragraphs, it is an admitted position. It's their petition, the same society. How can they say, my lord, that they are not admitting?
9 also.
9 also, my lord. 9, 10, 11, in several paragraphs.
That is not your writ petition.
Sir, this is not filed by me, Lordship.
Huh?
Lordship,
So this is filed by the society, not by you.
society, all the members, we have given the members society registration
Page-
certificate also, Lordship.
page
These are the very poor people, Lordship. And
54, my lord. Who is the petitioner, lordship? May kindly see. Page 24. 254.
Huh?
Page
Page
254. Who is the petitioner in this petition, lordship? May kindly see, my lord.
page 254.
254. Who is the petitioner?
Yes. The same.
Bokajan Sarvajanic
Huh.
Kalibari Committee, a society. The same petitioner as in this case. my lord. They have admitted in the whole writ petition, they have admitted that these are railway land. Our predicament is that, my lord, for the last 7 years, the sanctioned projects of the railways have got stalled, my lord. And these are projects of public importance. One project is construction of a railway underbridge, my lord, over the level crossing. my lord.
Lordship, Karbi Anglong
the sec-
Autonomous Council is a very necessary party in this.
Who?
Karbi Anglong Autonomous Council, Lordship.
Nothing to do. The railway land.
In-
Railway
No.
land, whether it's in Karbi Anglong area
But
or
the
in
same
some other.
circle officer has verified that is not the railway land, Lordship. I will produce the document, Lordship. Anytime you ask.
And in the second writ petition,
Sir,
my lord,
The name of the.
Just a
council,
minute,
Lordship.
I'll hear you.
Lordship, Lordship.
second writ petition, my lord, there was no eviction order. The order that was challenged before the learned.
The second eviction, the second,
Second writ petition.
there are two writ petitions.
In the writ petition, what was under challenge was the order cancelling the license of the affected parties, my lord. That order is not challengeable under section 9 of the Public Premises Act, my lord. Because it's only an order passed under section 5, 6, and 7 of the act that can be challenged under section 9 of the act. So that was totally not maintainable, and exactly that has been held by the honorable district.
Page,
In the other writ petition, my lord, lordship may find, lordship.
there's another writ petition.
Yes, yes,
Oh.
two writ petitions. Same society. Totally alien to the cause of action, my lord.
Now, out here, what was under challenge?
In this case, my lord, the affected parties were license holders from the railway. They were
License holders of what? Land?
railway land, from the license. Their licenses, either the period of license was over or railway had cancelled it in view of the requirement of the land by the railway, my lord. There is no eviction order under section 5.
Ah.
So this order cancelling their license would not have been challenged in an application under section 9 of the Public Premises Act. Because section 9 of the act,
So this cannot be challenged at all.
no, honorable district judge has held so, my lord, that it was premature and not maintainable.
So this has to be decided first.
This has to be decided first, and that is not maintainable at all. And even this one is not maintainable, my lord.
Anyway, we'll take this separately. Let's take up this only.
This-
So any citations?
So even lordship has decided.
No, I don't know anything. I need to refresh my mind also.
I'm not relying on any decisions, but these are admitted facts that this is railway land. There was an eviction order, my lord, that was challenged before the honorable district judge, and the honorable district judge has rightly decided the matter because the appellant who was before the honorable district judge was totally alien to the proceeding. The affected party the parties who are affected by the eviction orders, my lord.
Where is his pleading before the district judge?
The pleading. Lordship will-
Page 151, Lordship.
Page 158,
One-
appeal memo, my lord. It starts from page 158.
150. That's for 11. No, this very careful. You can get this answer. I'm sorry, my lord. Completed the second
158, my lord.
150. Fifty-one over, isn't it? 51.
What is there any, the appellate authority, is there any alternative remedy or this is the correct
This
remedy?
is a statutory remedy available under the act, my lord.
From the district judge to the high court?
From the district judge to the high court, my lord, this is not a statutory. This is procedural, my lord. And in fact, there has been a recent judgment of the apex court, my lord, reported in 2016 SCC, my lord, that a writ petition under 226 is not maintainable. What would be maintainable is an application under 227.
Right.
That I'm not going into, my lord. That I'm not going into. I'm on the aspect of maintainability on the ground that the affected parties were not before the president.
Yeah, you are quoting judgments, this, that, all in the air, nothing to back you up.
My lord, these are settled positions, my lord.
Settled position, you please teach us. We also got to learn from you.
Then the orders are not under challenge. My lord. These are all.
Yes, you have got, where is, you are, the parties who have been given eviction notices have not gone in challenge.
All list we have,
Huh?
all parties are there.
No, they're not there.
The Lord.
They're not parties.
Earlier, they approached through the Bokajan Sarbajan Kalibari Committee before the Honorable High Court. As per the submission of the railway, there alternative remedies available. Those parties went back for appeal, Lordship. But my main challenge, identical notice, Lordship, under section 4 is challenge that there are some judgment, Lordship. Notices were invalid. So the final eviction order suffered from infirmity, Lordship. That was my case, Lordship. So railway has to give the notice in accordance with law. This is the mandatory provision of law under section 4 and 5. And Lordship, appellate authority is the empowered to decide the appeal of under PP Act, Lordship. And High Court, I have approached only, Lordship, the perversity in the judgment, Lordship. That's why. So I would like to, Lordship, place some judgment here.
No,
notices
sorry.
are invalid.
Sorry. You have not exhibited any, you have not annexed anything in your civil appeal before the district judge.
Lordship,
No documents.
Lordship, we have an document, Lordship.
Where? Show me. This matter has been hanging since 2017.
Page 185, Lordship, it is
Huh?
submitted of page 185 onwards. We have submitted
185.
one. Yes, Lordship.
That's the Christie of documents, my lord.
Huh? 185.
Onwards, Lordship. All the documents there are like, that are under challenge, Lordship.
What is Christie? What is Christie?
List of the documents.
List of the
List of the documents.
Whether that document would make them a party
Because-
before the proceeding, my lord. And
Because,
whether
Lordship,
that be-
all the eviction orders were
becomes legally-
identical order, Lordship. One order, same date to all
No,
persons.
not
And
at all, my
some
lord.
names are wrong, some title are wrong, and that was issued in a bulk, Lordship. So that notice was invalid. Primarily, we challenged the notice, Lordship.
All the
As
evidence.
was the provision of law. That's why it was before the Honorable High Court, but it was directed to appellate authority, and appellate authority did not consider our all documents, what made we challenge in the appeal petition, Lordship. So let them at least consider our document, and Lordship, if the matter may be remanded back to him for pass order in accordance with law.
Mr.
after-
Counsel, is it your land?
No, Lordship,
Is it railway land?
I don't agree.
You don't agree? Okay, that's enough. I will record that. That's enough.
Lordship,
I will decide this issue only on the question of whether it is railway land or not.
Lordship,
right.
we may be allowed. to
Heard,
file
Mister?
SB
What is your name?
SB Prasad.
SB Prasad, learned counsel for the petitioner. Also heard Mr.
P. Sharma,
P. Sharma,
B,
B. Sharma, learned counsel for the
NF radio.
NF radio.
All the-
Lordship, I am please allow to the state map of the relevant.
Huh? No need, no need.
The Lordship, this
You
is the
said
grant-
that,
This is the grant.
you said that you don't agree there's railway land.
This is
That's
the
all.
grant land, Lordship.
Huh?
Grant land, issued by the circle office, Lordship, Karbi Angle. So that's why we asked time to file our.
I have also annexed the map, my lord.
2 or 3 days rejoinder I will file, Lordship. In the interest of justice, Lordship. Otherwise, they will
Last week,
suffer.
it took time for.
This has been pending since 2017.
Lordship, fix any date for final
No, no,
disposal,
no,
Lordship.
no,
Right.
But kindly allow us to file. our-
This appeal, this writ petition has been filed against the impugned Where is the judgment and order?
Page 308, my lord, Annex 18.
Impugned judgment and order. Judgment dated 6/11/16 passed by the District Judge Karbi Anglong, Assam, in Miss Bracket Civil Appeal number 05 of 2012, by which the writ petitioners, one writ petitioner, by which the writ petitioners case has been, petitioner's case under section 9 of the Public Premises Bracket Eviction of Unauthorized Occupants Act, 1971 has been dismissed, as being not maintainable. The brief facts of the case is that a number of eviction orders were issued on 2/8/2012 by the estate officer NF Railway, Lumding, Assam, under section 5/1 of the Public Premises Eviction of Unauthorized Occupation close, Act 1971, hereinafter referred to as the 1971 Act. The next para. Writ petitioner, which is the Bokajan Sharba Janin Kalibari Committee, represented by its president, challenged the eviction orders issued to the various persons by WPC number 4143/2012. This court disposed of WPC 4143/2012 by order dated 31/8/2012 by granting, by giving liberty to the petitioner to avail the alternative remedy available for filing an application, for filing a petition under section 9 of the 1971 Act before the district judge. Thereupon, the petitioner approached the court of the district judge, Difu at Karbi Anglong, by its civil appeal number 5 of 2012, challenging the eviction orders issued to the members of the writ petition. Next para. Civil appeal number 5 of 2012 was disposed of by the district judge, by the court of the district judge Difu at Karbi Anglong, by judgment dated 6/11/2017. By holding that the appeal petition was totally silent as to who were the members of the appellant society, namely, were the members of the present writ petitioner society. Further, the writ petitioner had not submitted any document before the court of the district judge, showing that any eviction order dated 2/8/2012 had been served upon any member of the writ petitioner society. The learned court of the district judge, Karbi Anglong, thereafter dismissed the appeal as not being maintainable. As there was nothing to show that any member of the writ petitioner society had been served with any notice. No. That's all. For that you cut, huh? Not maintainable. Full stop. The petitioner, being aggrieved by the impugned judgment dated 6/11/2017 passed by the district judge Karbi Anglong in Miss Civil Appeal number 5 of 2012, has thus approached this court, praying for setting aside the judgment dated 6/11/2017. Yes. Next paragraph. The petitioner's counsel submits that the that he doubts that the land which the petitioners are occupying, that the land which the members of the petitioner are occupying is railway land. Correct?
Then status note accepted.
Same thing.
No.
You doubt.
But we have document from.
He submits that he has documents showing that what?
Yes.
That's what?
Base map of the area.
Huh?
Base map of the area.
Showing what?
Base map of the area also.
You have got the sketch map of the area showing what? That the land is your land, the land is someone else's land.
Land is grant land also.
That the land is?
Jadhav Rai grant land.
Huh? What?
Jadhav Rai grant land.
The land is grant land.
Jadhav Rai.
Huh?
Jadhav Rai grant land.
Just like that. Jadhav Rai. Jadhav Rai land. I don't know
Grant
what.
land.
Huh?
Jadhav Rai grant land.
Jadhav Rai grant land. and thus does not belong to the railways. That's all it is. That's all it is. As such, the railways cannot evict the members of the petitioner society. He also submits that prior to issuing the order of eviction, the railway authorities were required under Section 4 of the 1971 Act. Give me Section 4, the 71 Act. Uh-huh.
Can hand over.
Otherwise, to issue notices to the members of the petitioner society which were not there. Which accordingly, in view of the violation of Section 4 of the 1971 Act, and the fact that there is no proof that the railways are the owners of the land in which the members of the petitioner society are occupying, the impugned judgment dated 6/11/17 passed by the District Judge Karbi Anglong in Miss Civil Appeal number 5 of 2012 should be set aside. First up, Mr. B. Sharma, the learned counsel for the railways, on the other hand, submits that the writ petition is not maintainable, inasmuch as none of the persons who were issued the eviction notices dated 2/8/2012 have approached this court or the district court, district judge Karbi Anglong. He accordingly submits that there is no infirmity with the decision of the district judge Karbi Anglong in dismissing the appeal, in the absence of the
Affected parties.
the absence of the affected parties who are unauthorizedly occupying the land of the railways. He also submits that the issue of the railways, the affected parties who had been issued notices having been are in unauthorized occupation of railways land is clear from the pleadings made by the writ petitioner in
Page 285. In the earlier round of litigation in WPC number 4143 of 2012.
In the pleadings made by the petitioner in WPC number 4143/2000. They accordingly submits that the writ petition should be dismissed. So I have heard the learned counsel for the party. As can be seen from the various eviction orders dated 2/8/2012, which is part of the annexure to the writ petition. The eviction orders were issued to the affected persons.
Page 135.
One such eviction order is being reproduced here below. Page 135 from here to here. Okay. Oh, it's still here, still there. Railway estate officer. Okay. A perusal, next para, a perusal of the above eviction notice shows that date of hearing of the case was fixed on 28/3/2012. However, however, the affected persons did not appear. Besides the above, no, next, full stop, next para. The affected persons who have been issued eviction notices by the railways have never approached this court or the district court in their individual capacity. Also, nor is there any authorization, nor have the affected persons given any authorization to the petitioner hearing to file the writ petition on their behalf.
Petition or the appeal, both.
But what about this? This thing is there.
Authorization is there.
Authorization is page 1, annexure 1.
Petition it is there,
Ah.
not before the learned.
Okay. What have I said? To file that
Appeal under section.
that civil appeal, civil misappeal. What is it?
Civil,
That's all.
Miss Civil,
She's right.
case number 5 of 2012.
Ah.
166 minutes.
Miss Civil Appeal number 5 of 2012. Though there is an authorization to file the present writ petition. This is made clear from para.
Para 11 minutes. Page 311.
Para 7 and 11 of the impugned judgment dated 6/11/2017 passed in Miss Civil Appeal number 5 2012, which is as follows. Page 310 and page 311. Next. Next para. Now coming to the question of whether the affected persons are occupying railway land, it would be profitable to rely upon, would be
Page
profitable to refer to the pleadings made by the writ petitioner in
Page 251 it starts, my lord, with petition.
in para 6. There are 6. Just a minute.
8 and 9. Ten. Thirteen.
Just a minute, I will say. 6. 8. 9. Of the writ petition in WPC number 4143/2012. Page 256, 57. Oh. Next. In view of the fact that you give me some citations with regard to maintainability that thing, no? So. No. We'll discuss this writ petition. Huh? This writ petition, what is this writ petition?
This is also not maintainable because the order that he challenged before this honorable court or before the district judge was not an order passed under section 5, 6 or 7 of the PPE Act, my lord. As such, the appeal under section 9 is not maintainable because, my lord, what can be challenged in an application under section 9 is an order passed under section 5, 6 and 7.
So,
And
This is with regard to what?
the cancellation of the license agreement.
What license agreement?
In this case, the petitioner claims that, my lord, the persons who are affected are licensees of the railways.
We'll see this, we'll dispose of some other way.
My lord, because, my lord, the project is getting stalled, my lord.
No, we'll take this separately. One at a time. The other one, you guys, on the prayer, the party leaves the matter after 3
My lord,
weeks.
Lordship, can you fix a date?
Forgive a date. You give me the citations
Mal-
regarding that.
Second,
Item number 46 is infectious, my lord.
Item for Mr.
A.M. Ahmed.
A.
A.M. Ahmed.
A. Ahmed, learned counsel for the petitioner. What means that the matter has been infectious?
Yes.
Who appears for the other side?
My lord, PNRD.
PNRD, Miss A. Lodha appears for the PNRD department. The writ petition is accordingly dismissed as infructuous.
Obliged.
मतलब in item number 19, my lord, मतलब government has filed an affidavit.
Ah.
मतलब government has no charge to us, my lord. I'm for a private respondent, my lord.
Madam, he is a private respondent.
मतलब we don't know, my lord, what is it, what there is can also.
Copy, it's okay, madam.
मतलब they have to, मतलब on Tuesday.
Who's for the petitioner?
I am for the
So they have not been given copy.
lordship.
Okay, you have to give them. You have to give them.
After 2 weeks, lordship.
Yeah, what is the basis for, how do you inherit a license? What is the basis? Huh? What is the law? How can you inherit a license, Mr. Potwari?
I don't. Our grievance is not regarding inheritance.
Then,
Pilot, I also applied. My application was forwarded by the managing committee. And by the private respondent also applied. And her application had the endorsement of the MLA. And that's why her case was considered and my case was not even considered. That is
so it's not on inheritance.
not only that.
Lordship, even he did not apply, madam. He did not apply. He applied before the, my lord, President Halakura Samobai Samiti Limited. So he applied before them. They have taken a resolution. Then they have forwarded to, my lord, the authority. But the private respondent, he herself have applied. Though recommendation was by MLA, it's okay. But my lord, she applied.
So what is wrong? Recommendation by MLA, what is wrong? Sometimes they can recommend also.
But applied before the competent authority, my lord.
No, Pilot, yes, being a people's representative, they can definitely.
They can always recommend.
Yes, yes,
It's
but-
part of their job.
But lordship, my application not been considered just because her application had the stamp of some political.
So his basic case is that
Lordship, kindly correct the
why
affidavit.
wasn't my case considered at all? That's all.
Lordship, what she is submitting my letter.
Huh?
submitting the-
My lord, he will be intimated, my lord.
What?
Whether his case was considered or
So
not.
what does your affidavit say?
Yes, I'll-
Our- my lord,
She is submitting is not from the record.
Ah.
On affidavit, they stated something, now they're saying something.
our affidavit says
Para
my lord,
four.
that the,
Is this fair price license shop given on the by way of a tender or what? No, then
on application.
So on
An
application,
application.
it's governed by Assam Public Distribution of Article Order.
And he did not apply, my lord. He
Okay.
applied before the, my lord, Samobai
Yes,
Committee.
I did not ever.
He did not apply before the concerned authority, the competent authority.
No, my lord, there is lordship, let her show where is the application procedure.
No, application procedure, but
if there
still,
is-
if
where is
he
the
wants to
procedure?
have, my lord, he will have to file, my lord.
No, you show first, you are objecting that I have not applied. That will kindly come to the affidavit, lordship. Affidavit filed on 29/2/2024. Where is paragraph 4 of the affidavit? That with regard to affirmance made in paragraphs 2 to 13 of the petition, the deponent begs to state as follows. That one fair price shop dealer, Sri so-and-so, bearing license number so-and-so under Alakura GPS was expired on 2/9/2017. Leaving his old aged wife who was above 70 years of age and 4 numbers of married daughters who were residing far away from Alakura GPS. So no legal heirs were found to apply for dealership as when deciding for. But once the particular because that is the petitioner, son of so-and-so, had applied for the new PDS license against the vacant place of Sri so-and-so with a nephew of the deceased fiber shop dealer. As per office record, it is found that the then managing committee of Halakura GPS on 15/11/2017 has recommended the name of Sri Pradeep Kumar Biswas to a resolution copy of the managing committee for issuing new fair price shop license in the vacant place of Sri so-and-so, which was duly approved by the Assistant Minister of Cooperative Societies, Dhubri. This is annexed 5 to our expedition. In this regard, another applicant, Srimati Krishnabala Adhikari, that is the private.
Which page are you reading?
My lord, I am reading page 48,
48.
running page 48.
Our
Ah,
affidavit.
okay.
Now, Roman two. In this regard, another applicant, Srimati Swanshaw, that is a private respondent, had also applied against the fair price shop on the date of Sri Swanshaw, while the application dated before the chairman secretary of Messrs. Halakura, but the same authority, I have also applied for before this authority only. And by the application dated 11/7 before the deputy director of food and civil supply and consumer affairs respectively. The secretary and the chairman of Messrs. Swanshaw has forwarded the application dated 9/10/2017 to the then director of food and civil supply, with endorsement dated 22/12/2017 for taking necessary action from this end. But the managing committee of Halakura GPS has not forwarded any resolution copy by proposing the name of Srimati Swanshaw for granting new fair price shop license against the Swanshaw. Next, in this connection, the then area officer of Messrs. Halakura GPS has submitted a report in favor of Srimati Swanshaw for issuing a new PDS retail license against the existing vacant post of Swanshaw, and accordingly, new PDS retail sale license right order memo number so-and-so was granted to her bearing number so-and-so. It is also mentioned that on 12/3/2018, Sri Pradeep Kumar Vishwas, that is the petitioner, had submitted an.
Okay. Now I think you give the affidavit to him, then we'll
Lordship.
take it up on some other day.
Lordship, Lordship.
Okay, right, Mr. Huh? D. Gogoi, submit that he has not received a copy of the affidavit filed by the government. The government shall give a copy of the same to him. Government council shall give a copy of the same to him. This is the matter after the week. Deeply.
This matter is most probably become infectious.
I think it has become infractions, no?
Settlement is already over, your lordship.
Huh?
Settlement period was 2020, it's already over.
None appears for the petitioner. It is seen that none appeared for the petitioner on the last date also. Mr. R.R. Gogoi appears for the Forest Department. The matter pertains to allotment of work order for extraction of sand and gravel for the period from 2014 to 2021. As no one appears for the petitioner, the matter is dismissed for non-prosecution.
All right.
I paid for 4 weeks time to also obtain instruction also. And last occasion I have communicated the ministry has sought 4 weeks time.
Mr. K. Gogoi, learned counsel for the
Respondent number 1.
point number 1. And Mr.
And Kalita for 2, 3, and 4.
and Kalita for response number 2, 3 is found granted 4 weeks time to obtain instruction and file affidavit is necessary. This is after matter after 4 weeks.
The date may be fixed.
Huh?
The date may be fixed, Lord.
No hurry, 2019 matter. Acha, your name? Mr. D.D. Sharma appears for Mr. M. Data for response number 3. Then this item 22.
May please, your lordship.
Yes,
Lordship, this is, the matter is about non-payment of bill.
food
Lordship.
bills.
The petitioner supplied.
Yes,
food
madam, what to do?
refreshment. Lordship, in idea that we have already submitted the instruction, so it's 100%. Lordship, by the order dated 26/2/24, Lordship. This,
26 to 24.
yes, Lordship.
Yes,
NRD was asked to submit positive time frame within which the payment of the petitioner was to be released.
yes, madam.
Lordship, it's 100%.
Should we call your secretary?
Lordship, can they 2 weeks time, maybe? Lordship? We will get up to the instructions.
You are supposed to give a positive time frame, madam. This court has directed. We don't want, you see, there's no point listing a case time and again just for adjournment. This court has asked you to do something. Why don't you do it? You have to give a time within which it will be paid.
Actually, it's under process. The for financial sanction from the finance department.
You please tell your secretary to pursue the matter. Okay. Miss N. Bora, Learned Counsel for the PNRD Department, submits that the payment of bills to the petitioner is under process. And the same is pending with the finance department for sanction. Who is for the finance? Finance is the party here.
Not very party.
Make them a party, madam. Make them a party. List the matter after 2 weeks.
Structure the dates may be kindly fixed.
Make them a party, no point. They're going to say the same thing next week. They're going to say still with the finance department. You make them a party. Party 23.
Please, your lordship. Lordship, records not received. I don't know if this 2 weeks time may be given.
Last
Is
week,
the, huh?
last week, I'm directed to put in the record,
Record.
perhaps the record is not received.
Received.
Miss
M. Das, my.
M. Das appearing for the PWD.
W.
Submit that she hasn't been given the records. Accordingly, this is that after 3 weeks.
My lord, 47 also similar.
To enable Miss M. Das to produce the records.
47 also.
47 also same order.
Also, may I pay for one fixed date, lordship?
Huh?
Item 23, may I pay for a fixed date, lordship?
47 is slightly different.
My lord, same
Similar
process.
matter, lordship.
Similar.
Whatever means you-
But out there measurement has to be done. Anyway, okay, 47 same. Same order. Next.
Deep development.
24 and 25.
My lord, in this case, as per the last order, they were supposed to file the affidavit by 4th of March. Earlier also, they took time, that the government took time to file.
My lord, actually, my lord, the Sapor Municipal Board is the, my lord, main party here, my lord, because agreement was with the.
What
Sapor-
board? What board?
Sapor Municipal Board, my.
Support.
The
As per
government
the
advocate
number-
accepted notice, and in fact, also you may have a look at the order
My
of.
lord, executive officer was, my lord, functioning, my lord, so that's why.
Support Municipal Board.
Yeah.
No, acceptance of notice by a
No, my lord,
person.
on a last occasion, that is the order passed from 16-2.
Ah.
Government advocate was directed, he prayed for time, 16-2. So the government advocate who representing the Chapar
N.
municipal.
Goswami.
Inform, my lord, I'll inform the municipal board if they engage some other council.
Yeah,
okay, but
So you're not representing the municipal board.
Cannot, my lord, now, my lord, because they.
Earlier, in lordship may have a look at the order of 29-10-2021. Then also the government advocate represented the municipal board.
At that point of time, my lord, municipal board was not functioning, my lord, it was represented by executive officer, my lord, that's why we accepted, my lord, we'll intimate, my lord.
Not acceptance, sir. It is after the notice. Lordship may have a look at the order of 29-10. There also the government advocate representing the municipal board sought for time. Then again on 16-2, government advocate representing the, and now a different stand, my lord.
I'm not taking different stand, my lord, because I have
Exactly.
seen, my lord, support municipal board, now they are functioning, my lord, municipal board is functioning. My lord, it's a, my lord, maybe grant some time, my lord, I'll do the, my lord, I'll intimate them whether they will file through us or, my lord, they engage some other council, my lord, I'll take up the, I'll intimate.
Miss
You does, my lord.
Udas, Learned Counsel for whom?
For my lord, 1, 2, 3.
1, 2, 3. Submits that she will inform the Chapar Municipal Board regarding the pendency of this case and I'm trying to obtain instructions. List this matter after 2 weeks.
My lord, there is an interim order.
Interim order to continue to the next week.
May I pray for a fixed date, my lord?
It's April something.
26 to 30.
Date?
With 3 weeks.
May I please?
Last occasion, I was directed to file affidavit that we have received an instruction on 8/3 Lordship. There is some dispute regarding the contractual due. So we take further instruction whether
Mr. Council, you all are always asking for time through letters all the time. Last time also we have submitted a letter.
Lordship.
Last time it was for 6 weeks. Now it's for 4 weeks.
4 weeks.
What is so difficult?
Lordship.
Should we call the officer here?
After 2 weeks, Lordship, I will file affidavit and ascertain whether there is a dispute or not Lordship, regarding the claims.
Mister?
Yes, Doctor.
Yes, that land council appearing for
Right. Restaurant number 7.
response number 7. Submit that he will obtain instructions within 2 weeks with regard to the liability. With regard to the contractual dues payable to the petitioner, leave the matter of 2 weeks.
Obliged.
31.
No one appears for the petitioner on call. Yes, what to do in this case?
Here, my lord, while saving the stamp paper, my lord, they did not make the entry, my lord. So against this corrupt practice, my lord, the charge,
Cancel.
my lord.
Right, no one appears for the petitioner on call. Miss U Sharma appears for the
My lord, my lord, I'm for 2 and 3 months.
2 and 3. While Mr. S Datta appears for
One.
point number 1. The affidavit in the position filed by the state respondents is to the effect that the petitioner had not filled up the back side of the stamp paper which has been sold by him, leaving the same to be misused by others. Accordingly, the stamp vendor license issued to the petitioner had been cancelled. Full stop. Accordingly, in the interest of justice, this is the matter again after 2 weeks.
32.
Don't say accordingly you cut, huh? Accordingly you, in the interest of justice. My lord, they say appointment of arbitrator, my lord. Right? Yes.
Right, order dated 15/2. My lord, there was a direction to furnish instruction, my lord, as to the, my lord, the page, my lord, will see the order dated 15/2.
Huh?
Order dated 15/2, my lord. The direction was whether the chief engineer has taken any decision or not, my lord, page 46. Because they have done some extra work, to which my lord has asked us to take instruction whether the tender evaluation committee has taken a decision or not.
Hmm.
So, my lord, as on date, the tender evaluation committee has not taken any decision. My lord, in my humble submission, that the arbitration is premature because the chief engineer has to take a decision first.
Yeah.
And after the rejection,
But if you're not taking a decision, then what, we can't wait for kingdom come to.
my lord, may
Yeah,
I say
await a
that a
decision.
direction may be issued to, in terms that let the authority take a decision, chief engineer, if the dispute is accepted, my lord, they will get the relief, whatever they are seeking
Unless
for.
section 11, my lord, how it, it will be issued by the court, my lord. Court can appoint an arbitrator, my
No,
lord.
no, but then, Mr. Savala, this
Yes.
thing is additional work
46 now.
is not part of the original contract agreement.
Yeah.
So maybe, my lord.
In the contract agreement, is there any clause which provides that the additional works, if any, will be covered by the contract agreement?
So that the page 20
Works has already been done, my lord.
Huh?
my lord, page 21,
No, but then you have got to take a decision, Mr. Counsel. We cannot wait like this.
my lord.
This case has been filed in December. 3 months have passed, 3.5 months.
I'll take instruction, I will ask them to take a decision.
They have to take a
I
decision.
will make an observation on that effect.
Because only one thing is, if you are not taking a decision, it becomes a problem.
It's an admitted, executive engineer has already admitted that extra work has been done.
Have been
He has
done.
also figured
Okay,
out the.
so now is you are not being paid your
The
money or
chief
what?
engineer has to approve it. The chief engineer has to take a final decision on it.
So, okay, if the chief engineer approves it, then your job is done.
Yeah.
Let him take a decision. Chief engineer, we direct that within a month, he should take a decision.
Yes.
And if it's against you, then you go for arbitration.
Let it be pending, my lord.
Yes, they'll be pending.
Yes.
I heard Mr. G. S. Sahewala, learned senior counsel for the petitioner, as well as Mr. H. Gupta, learned CGC for the responding. The Mr. H. Gupta, learned CDC submits that the additional works carried out by the petitioner in terms of the letter dated 28/2/2019 issued by the superintending engineer, Government of India, Ministry of Water Resources, River Development and Ganga Rejuvenation, Jorhat Circle, Brahmaputra Board. Is to be approved by the chief engineer, by the concerned chief engineer. He accordingly prays for some time to let the chief engineer take a decision on the matter. On considering the prayer of Mr. H. Gupta, the concerned chief engineer, respondent number
3,
respondent number 3, shall take a decision on the petitioner's additional works and non-payment of the same, and non-payment of the contractual amount. Leave this matter again on after a month.
No.
Give a date.
33.
Public.
Give a date.
May I please, Your Lordship? This is with regard to the appointment of arbitrator which your Lordship had heard earlier. Now, for the sake of,
What is this matter? Wait. This thing. In that file. Maybe. Yes, arbitrator has to be appointed. What is this?
You have been appointed.
Huh?
Has been appointed.
They've been appointed.
they had appointed before, after we came before this.
No, Lordship. We only corrected.
Your
the law.
Lordship may kindly see the list of dates which are for the purpose of.
Yes, yes.
Now, the agreement which was entered, the arbitration clause is at clause number 34. Now, we by 31/5/23, we issue notice seeking appointment of an arbitrator. There, and thereafter on 27/6/23, respondent writes to us seeking waiver of 12/5.
12/5 is what?
12/5 is the neutrality of the arbitrator that both parties, as of a date after the amendment.
So what did you, so? You
So we did
refuse?
not waive that particular
then-
clause because on 3/7/23, we
Ah.
categorically refused
Ah,
to waive the applicability
correct,
of
then,
the neutral arbitrator.
then-
Means 12/5. So as per that amendment, so a person who has no affiliation with the department will have to be appointed.
yes,
So thereafter, on 2/8/23, they sent a name of 4 panel arbitrators in compliance of clause 64 of the GCC. 64 is not applicable in our case. 64 is contractual, 64, it deals with contractual parts of the railway. We refused to appoint by our letter saying that 64 does not have a bearing with our case. Because
so what
our-
is applicable to you?
it's clause 34 of the arbitration act, the agreement. The 64 they are referring to,
Let us see 64 and 34.
34 your lordship will find in our page 172 of our application, your lordship. And the type copy your lordship will get at page 150 AJ.
What is it? 150 AJ, there is AJ.
No, your lordship will find 172.
You've got 150, so many 150s.
Because it was typed out. Initially it was, the office rejected that, saying that it was illegible.
Your 150 is this many pages.
No, your lordship will come to 172, your lordship.
Yes,
172 arbitration clause is there. If your lordship see.
yes.
In the event of any dispute or difference of opinion between the parties as to the respective rights and obligation of the party herein under the true intent and meaning of this party of any conditions thereof arising such dispute or difference of opinion, except the matter regarding such and such. This agreement shall be referred to an arbitral tribunal consisting of at least 3 members to be appointed by the general manager NF Railways for the time being, and his decision shall be binding. So after the amendment of the Arbitration Act, the general manager himself has become ineligible to make any appointment. There are judgments which your lordship, I will place your lordship for that. So once that comes, the appointment by him is not effective because of the amendment of this. Now they come forward and say that they bring on record a clause which is applicable to the general contract, which is not a part of this GCC of
GCC is not, GCC is separate.
this is separate. GCC which they have referred to is this, your lordship.
Yes, yes, that's the general conditions of contract
General
which they
conditions,
use in all other
And your
contracts.
lordship will
So
find
for here, there's a
it is
spare,
not applicable.
there's a contract agreement.
So
specific.
what we did, by the very next letter, we said that ETC, this particular clause 64 is not applicable to us, which your lordship will find at annexure as we have stated specifically in the list of.
No, no, you have given me this. For what did you give me this?
Because this
So what do you want to show me?
64, here your lordship will find the first covering letter, amendment of this, they are saying subsequent to the promulgation, subsequent to the promulgation of Arbitration and Conciliation Act, clause 64 of the GCC of 2014 is being amended. This is a totally
Has
different,
been modified. What
this
do
is
you
been
mean?
modified, which is not applicable in our case because this is nowhere related to our case.
What does clause 64 say?
Clause 64, there are three different parts. Your lordship will come internal page. There is no internal, this is the circular they have given. 64(3) is a appointment of arbitrator, your lordship will find. If your lordship has got it.
So so even if 64 is used, even if 64 is made applicable, then if you have denied waiving of, or you have not agreed to waiving of
Yes.
the applicability of 12(5),
Yes.
then also that bar of
That is
appointment is there. Then how does it matter whether you use
are
64 or 64 or 34? How does it matter?
Then they unilaterally on 13/10/2023, they appoint 3 persons. One
1310?
unilaterally, without giving us the option, they appoint 3 persons as the arbitral tribunal. One is a retired person and 2 are serving engineers, serving officers. On
Uh,
13/10/20,
And you file this writ petition now?
immediately we raise an objection that these are not maintainable because they are all.
Before the writ. Anyway, yes, so basically, so there you have appointed 3 persons. Now, can you appoint 3 persons?
Yes, lordship.
Under what provision?
34 says so.
Sure,
Lordship.
but 34, won't it be hit by 12(5)
12/5 is hit.
and the schedule and the
That-
7
that
schedule?
question has been dealt by the lordship, this central organization, railway election case lordship. The other day, Paris, the copy is there.
Oh, yes, you had given me
No.
somewhere.
Now you're
You
lordship.
had given me, I had kept it for reading, I kept it somewhere. Ah,
I have a copy, your lordship.
yes, I just want to go.
I will spend on it.
And these are the 2 other judgments by which it has been referred to the
You
larger.
know, the way you speak, you speak a lot like Justice Rishikesh. Voice and the way he speaks. Have you noticed any similarity?
Pardon, lordship?
You speak a lot like Justice Rishikesh Roy. Have you told him? 1 minute, huh? Just do it.
And lordship, then lordship, this, now the in Tatia case lordship
Just a minute. Wait, but you see, this judgment,
has been now referred to the luxury bench.
not only that, I think there was something else besides that.
Lordship. Now what should
It
be
has
the-
not been, yes, I mean, something, I don't
This is
remember.
dealing with clause 64, your lordship. This is that is
Tatia
what
case
I'm
has
trying
been
to say. Page para 37,
Just a minute. Para?
38.
before that, your lordship may go through.
Just a
para
minute,
37.
one at a time. You'll get your chance.
38. lordship. There is an express provision in the modified clause of general condition of contract so and so. The arbitration consists of a panel of 3 gazetted railway officers and 3 retired railway officers, retired not below the rank of senior administrative grade officers. When the agreement specifically provides for appointment of arbitral tribunal consists of 3 arbitrators.
Now, when the agreement specifically provides, now the question is,
34
which
provides.
34 provides?
Provides.
Okay.
Provides. Now, lordship, if this matter is pending, what should be the court do, lordship? That has been explained in the decision, Lordship, the earlier judgment should prevail if there is no stay order. That is what Supreme Court has said.
Where is it said that where the contract agreement states?
Lordship, page 172.
No, no, in this para 38, where does it say that? Acha, para 39, no,
Let me confirm.
where there is an express provision, where does it? There was something, I don't remember. Yes. This judgment has not been looked favorably in other judgments also. I mean, they have not agreed with this. Anyway,
Yes, Lordship. That is why the matter has now been referred to the larger bench, Lordship.
that's the way.
In two judgments, it has been referred to the larger.
And the matter is pending. No stay order has been passed.
Where's that? Where there's an express provision? Acha, when the, yeah, para 39. When the agreement specifically provides for appointment of so. Okay. So that is there. And then in this Tantia, what is there?
Yes, Lordship, this has been referred to larger bench, Lordship. Now, what should the court do in case of such cases when the matter is pending before the larger bench? For that, Lordship, I am submitted another judgment, Lordship. That may be looked into.
And this is another judgment by.
Just a minute, what?
This Union Territory of Ladakh and others versus Jammu and Kashmir, Lordships.
Now, what about this JSW Steel?
That
This
is
is
also
also
pending.
another
All those
judgment by
cases are
which it has
pending,
been
Lordship. Lordship, paragraph 35.
Just a minute. Just a minute. Para 35.
35, Lordship. May I read, Lordship?
Yes.
We are seeing before us judgments and order of by high courts, not deciding cases on the ground that the leading judgment of the court on this subject is either referred to larger bench or a review petition relating thereto is pending. We have also come across example of high courts refusing deference to judgment of this court on the score that a later coordinate bench has doubted its correctness. In this regard, we lay down the position in law to make it absolutely clear that the high courts will proceed to decide matter on the basis of the law as it stands. It is not open unless specifically directed by this court to wait an outcome of reference of a review petition, as the case may be. It is also not open to the high court to refuse to follow judgment by stating that it has been doubted by a later coordinate bench. In any case, when faced with conflicting judgment by benches of equal strength of this court, it is earlier one which is to be followed by the high court, as held by this so and so, so and so. So the earlier one will be the Tatia one, which has been deferred, Lordship, cannot be followed now. That is what has been stated by the Supreme Court, Lordship.
I'll try to.
That is my submission, Lordship. So that,
Okay, got your submission.
Lordship. So the railway electrification case will follow, Lordship.
So let us hear the other side now.
Now, your lordship, the judgment which he has referred, para 37 of that judgment may be looking, because here is a case where we have not waived off the provision of 12.5, as your lordship was. Now, para 37 of this judgment of central, the court judgment, your lordship.
your lordship will find clause 64(3)(b) deals with appointment of arbitrators where applicability of 12(5)
Yes,
has not yet been waived. In terms of clause this, an arbitral tribunal shall consist of a panel of 3 retired railway officers. This is what I want to emphasize upon. Till we came before this honorable court, even assuming clause 64 is applicable, and even assuming this particular judgment holds the truth in our case, then also, as we had not waived of 12(5), this particular judgment is quite distinguishable because in this case, para 38 says they had
no, but you see,
they had furnished the list.
there's a problem here. You are saying that 64 is not applicable. Now, if 64 is not applicable, that waiver clause is in that 64, it is not in 34.
Yes.
Then how can you say, how can you,
No, 12(5) is for the arbitration act. Here.
correct, 12(5) is there for the Arbitration Act, and as per, now, despite that, in this case of central organization, the 3 judges bench has said that when there is a express provision for appointing an arbitral tribunal,
The court should
They
follow,
follow
that.
that. Huh.
But here there is a distinction. In this case, they had furnished the list of 3 retired persons.
huh,
But in our case, they did not furnish the list of 3 retired persons. They furnished 1 service of retired persons and 2 serving officers,
That has been rectified, lordship.
which is the provision which should have been, if they had given me a list of only 3 retired things, I would not have a case. But even assuming 64 is applicable. But here they
what is
did
that?
not furnish the list.
Eastman Perkins, what is that judgment? Which one is the citation? No, it's okay. Where they have got it.
2020. Yes.
Huh? 2020?
2020.
760.
I have a
Okay.
copy of that.
Just give me that.
Okay. TLF and TRF. 2 judgments are there, TRF and Perkins. Judgment. Okay. In TRF para 54, your lordship will find. That is 2017 8 SCC, page 377.
54.
Yes, 54. In such a context, if your lordship has got it,
Yes.
the fulcrum of the controversy would be, can an ineligible arbitrator, like the managing director, nominate an arbitrator who may otherwise be eligible and a respected person. As stated earlier, we are neither concerned with the objective nor the individual respectivity. We are only concerned with the authority or the power of the managing director. By our analysis, we are obliged to arrive at the conclusion that once the arbitrator has become ineligible by operation of law, he cannot nominate another as an arbitrator. The arbitrator becomes ineligible as per prescription.
Okay.
Contained
Got it.
of the-
We'll follow your judgment. That one which says that the earlier judgment has to be followed. Now the judgment you have produced is of 2020. This is of 2017.
Equal strength, lordship.
Equal strength. 3 judges. Deepak Mishra, A.M. Khanwilkar, Mohan M. Shantanu.
And as your lordship was asking, the other judgment of
Perkins.
it is there, your lordship. Here, it
TRF
starts
has been-
from para.
Huh?
TRF has been dealt with in the central electrification case, lordship.
What?
TRF case has been dealt with, lordship.
Maybe dealt with, but still, it has, I've got to go by the earlier judgment.
Whether that was pre-amendment or.
No. This talks about 12.5. 12.5. Talks about 12.5 here.
In this case, your lordship, a person, para 21, relying on TRF, had again gone ahead to discuss the same point, saying that the neutrality of an arbitrator is the foremost concern while a court has to appoint. Because if there is any reasonable doubt with regard to any bias, here also they have come forward with another thing, saying that the panel they said, it should be the entire panel. They cannot select only 4 persons and say, because the managing.
No,
director-
now that is gone. So now I will have to, this court will have to select.
Yes.
Once you cannot select, only this court can select.
Like he has invoked 34, that is his application is.
Huh?
He has filed his application annexed to the petition lordship. Page to 54, he has invoked 34.
Yes, he has invoked 34, but we have got to follow the law laid down by the Supreme Court.
But 34 says that they will retire, railway you appoint 3 arbitrators. That is
Mr.
also-
Council, the 2017 judgment, you take it up with the Supreme Court.
But he has not changed the provision of this also. But his own application is under 34. His own application is under 34.
You see, just because he doesn't challenge it, and if it's in violation of
His
what,
own admission is.
if it's in violation of a Supreme Court judgment, should we say that just because he has not challenged it, we should ignore the Supreme Court judgment?
By conduct also lordship. His own application is.
Mr.
on-
Council,
under
it is a
34.
simple law point. When the law says A is A, should I say, just because he didn't say A is A is equal to B, should I say that?
That's a different law.
Unfortunately, yes, it talks about 7th schedule also. I'm going to follow your very judgment.
Lordship.
You have to look at this for your benefit also. Look at it if you want. Just show it to you. Para 50 and 54. 7th schedule, 12.5 both are there.
The printed copies are submitted here also, of both the judgments, PRF and Perkins.
Oh, wait a minute. Another thing, Mr. Council, this 17, oh, this, okay, 2019. Still, 2009.
And Perkin came in 2020,
20.
which follows the TRF judgment.
Yes.
So,
Okay, right. Heard, Mr.
A. Biswas.
A. Biswas. Learned counsel for the petitioner. Also heard Mr. J.
D. Checker.
B. Chaudhary for,
Chakrabarti.
D. Chakrabarti for
All the respondents.
all the respondents. The learned counsel for the petitioner. No, the present petition is for appointment of an arbitrator under section 11(6) of the Arbitration and Conciliation Act, 1996. Correct? That's all. Good stuff. The petitioner's case is that what was your case about? I have to write something.
Your Lordship, we entered into a contract with the respondent on 2/7/2018. And which we have annexed at Annexure C. And
Just a minute. The petitioner's case is that the petitioner entered into a contract with the respondents,
the respondents, Your Lordship.
with the respondents to build and operate a 25,000 empty capacity godown with private siding under the private interpretation godown scheme of the FCI. Full stop. Consequently, contract agreement dated
2nd of July 2018.
2/7/2018 was executed between the parties. Full stop. No, disputes having arisen between the parties, comma. The petitioner has filed this application for appointment of an arbitrator, comma, even though section 34, clause 34 of the contract agreement provided for resolution of disputes between the parties by way of arbitration. Yes, sir. Next paragraph. Mr. B. Chakrabarti, the learned CGC submits that in terms of clause 34 of the contract agreement, page
172.
contract agreement, comma, an arbitral tribunal is to be constituted by the consisting of three members to be appointed by the general manager, NF Railway. Full stop. He submits.
And we currently send him a letter of 29/8/23.
He submits that as the contract agreement specifically provides for appointment of an arbitrator by the general manager, NF Railway, comma, the same has been done by the authorities. Same has been done by the respondents. Full stop. He also submits that there are conflicting decisions with regard to appointment of an arbitrator. Of an appointment of an arbitral tribunal by the Supreme Court in the matter of not in the matter of White Central Organization for Railway Electrification versus MS-ECI-SPIC-SMO-MC, reported in 2020 SCC 760, and in the case of Perkins Eastman, so 2020 SCC 760. What's that? Huh? Huh? What's that say? Acha. Wait. The first one will be the second one is 2020. Yeah? First one will be the first one will be the first one will be 2020 14 SCC 712. Yeah. What's that? He submits that as there are conflicting decisions between the three judges benches of the Supreme Court pertaining to the interpretation of section 12(5), 12(5), and the seventh schedule of the 1996 Act, comma. The earlier judgment passed by the Supreme Court would have to be followed by this court. He further submits that the conflicting decisions of the Supreme Court have been referred to a larger bench, comma, which has not decided the issue till date. I have heard the learned causes for the parties. The issue to be decided here is with regard to whether the General Manager NF Railway could have appointed 3 officers, bracket retired slash serving, bracket close, as members of the arbitral tribunal in terms of clause 34 of the contract agreement dated dash. Next para. Clause 34 of the contract agreement dated dash states as follows. Page 172.
170.
Next. Section 12 bracket 5 of the 1996 Act. No, and the 7th schedule.
Yes, okay.
As in the 7th schedule, as amended in the year 2015. Is reproduced here in below as follows. To stop. In the case of, no, in the case of, TRF Limited versus Energo Engineering Projects Limited, 2017, 8 SCC 377, cover. Had to decide two issues, which were as follows. Number one, invert commas, where once the person who was required to arbitrate upon the disputes arisen under the terms and conditions of the contract becomes ineligible by operation of law, comma. He would not be eligible to nominate a person as an arbitrator, comma, that is, whether the managing director of the respondent, comma, who had become ineligible to act as an arbitrator subsequent to the Arbitration and Conciliation bracket Amendment Act 2015, comma, could not have also nominated any other person as arbitrator. Number two, whether challenge to an appointment of arbitrator nominated by managing director, comma, and could only be made before the arbitral tribunal, or the same could be raised before the court in application preferred under section 11(6) of the Act, invert commas close. The next para, the 3 judges bench of the Supreme Court in TRF Limited. Where is that? Para?
In PRF, if you are not able to get it, para 54. And Perkins, in Perkins.
Yes, Emily. What have I said? That's held that. That's answered the issues by holding that. There is no quarrel that by virtue of section 12 bracket 5 of the 1996 Act, comma, if any person who falls under any of the categories specified in the seventh schedule shall be ineligible to be appointed as the arbitrator. Full stop. There is no doubt and cannot be, comma, for the language employed in the seventh schedule, comma, the managing director of the corporation has become ineligible by operation of law. In para 54 of the said judgment, comma, the Supreme Court further held that in such a context, comma, the fulcrum of inverted commas, as held at para 54 that an eligible arbitrator like the managing director cannot nominate another person as an arbitrator in view of section 12(5) of the 1996 Act. Para 54 of the judgment passed in TRF Limited, Supra, is reproduced below as follows. Okay. Next, in the case of Central Organization for Railway Electrification, comma, the three judges bench of the Supreme Court held that when a contract agreement specifically provides for appointment of an arbitral tribunal consisting of 3 arbitrators from out of the panel serving or retired railway officers, comma, the appointment of the arbitrators should be done in terms of the agreement as agreed by the parties. First up. Next, as can be seen from the conflicting decisions of the Supreme Court above and the subsequent decisions of the other 3 judges benches of the Supreme Court, like in Perkins, Eastman, so 2020, 2020 SCC 760 and Union of India versus Tantia Construction Limited 2021 SEC Online SC 271, comma. The conflicting decisions have been referred to a larger bench for final resolution of the issue with regard to whether the express terms provided in the contract agreement would hold sway while constituting an arbitral tribunal in the presence of section 15 bracket 2. No, section 12 bracket 5, section 12 bracket 5 and the 7th schedule of the 1996 Act. Full stop. Next paragraph. The issue that has to be decided by this court is as to which judgment should be followed. Full stop. In this regard, the learned CGC has submitted the has taken this court to the judgment of the the judgment of the Supreme Court in Union Territory of Ladakh and others versus Jammu and Kashmir National Conference and another. Reported in 2023 legal bracket SC 891, wherein it has been held that when faced with conflicting judgments of benches of equal strength of the Supreme Court, comma, the earlier judgment has to be followed by the High Court, comma, which would be in consonance with the decision of the 5 judges bench of the Supreme Court in the case of National Insurance Company Limited versus Pranay Sethi. Reported in
207,
2017
2017,
16 SCC 680. Next. By applying the judgment of the Supreme Court in Union Territory of Ladakh and others, comma, this court is bound to follow the judgment of the Supreme Court, the earlier judgment of the Supreme Court with regard to whether the managing director of NF Railway could have constituted the members of the arbitral tribunal in terms of section 34, clause 34 of the contract agreement dated 12th. Next. As the earlier judgment of the Supreme Court is TRF Limited, Supra, comma, this court holds that the appointment of the members, appointment of the serving / retired officials of the railway as members of the arbitral tribunal is hit by section 12 bracket 5 of the and section 12 bracket 5 and the 7th schedule of the 1996 Act. As their neutrality would be in question. That's correct? Yes. In that way of the matter, comma, the appointment of the 3 members of the arbitral tribunal by the respondents is set aside. Consequently, in terms of section 11 bracket 6 of the 1996 Act, this court is of the view that this court appoints who?
Your Lordship, a list that has been published on 4th of August.
You choose. Who do you want? Both of you.
Yes.
Yes, you can have a standing committee.
Okay, retired district judge Nirmal Kumar Bhattacharya is there.
Okay. Appoint so as arbitrator who will decide the dispute that has arisen between the parties. Full stop. The parties shall, the parties have both agreed to the choice of so and so, huh? And accordingly, they shall appear before the said arbitrator. When? Within a period of?
Lordship may fix, Lordship may.
Within a period of 3 weeks from today. Full stop. The issue of whether the petition, the arbitrator is what handicapped by the provisions of section 12(5) and the 7th schedule of the 1996 Act would be is left at the hands of the parties. Okay, and I think that's better. You can decide that. It's left at the hands of the parties. The writ petition is accordingly, the application petition is accordingly disposed of.
Highly obliged.
Huh? How you did this? You take that follow the hand.
Item 34.
Yes, madam, what's happened?
Lordship, but issuance of gun license, my
I know.
But, my lord, we haven't received instruction, my lord. May I pray for some more time, my lord, so that. I
Madam,
can
this is
positively
more than a
get the
year.
instruction. Lordship, I have seen, my lord, the letters my colleagues have written, and one letter I have seen, my lord, issued by the Deputy Commissioner of Police Crime, my lord, to the Secretary Government of Assam Women Political Department, my lord, for furnishing, my lord, parawise comments directly to the, my lord, government advocates.
But this is taking so much time.
My
1
lord,
year.
so, my lord, maybe grant sometimes so that I'll take the
Otherwise, we'll call them.
Lordship, maybe please to fix and give a last chance to file, my lord.
Where is it? Where is the application? Before the district commissioner, Dibrugarh?
District magistrate.
District magistrate.
Dibrugarh.
Uh,
That letter has 21, page 21, my lord.
Huh?
He has applied on 25th of June 2018, my lord.
Then, now it's 24, madam.
Lordship, may I?
I think we'll call him.
Lordship. I pray, my lord, that chance might be given and I may.
You're right.
Lordship,
Miss,
may I-
yeah.
I'll try to get it.
He applied, it was during the year of 2018, Lordship. But as he was intimated that since it is from 2018, he may reapply. So after filing of this writ petition, Lordship, last year on 2023, again he reapplied.
When's that?
Police verification.
When?
Putting those documents on record, Lordship, I have to file an additional
You
application.
file it? No, in the meantime, you get. When did you file?
Did you file for one?
When did you file? Huh?
No, no,
When did you file?
No, I will file. I have to file.
no, application का petition delay. When did you file the?
23, Lordship.
23,
23.
27/4. 27/4.
When this file. Yes, Lordship, 27.
You came to this court on 31st March 23,
Yes,
and just 27 days later you filed the application. What is this?
No, Lordship, may I submit, Lordship? He filed this writ petition with the application which he applied in 2018. Later on, as he was intimated that his application pertains to 2018, he should file new application by the respondent of only he was intimated, Lordship. So after filing of this writ petition, Lordship, again he have reapplied.
Why?
Same thing, after.
Madam, when you have come here,
Then-
you don't have to go there again.
Yes, Lordship, he was intimated like that, then those.
Then you go there, you withdraw this. What is your name?
S.A. Ahmed, Lordship.
Miss S.A. Ahmed, learned counsel for the petitioner submits that soon after filing of this writ petition, she was informed by the SP.
Lordship.
SP whom?
SP Digrigar, Lordship.
Huh?
As per my petitioner's instruction, it is like that, Lordship.
Petitioner was instructed by whom to file a separate application?
Not separate, again, new.
New by whom?
SP Digrigar, Lordship.
By the SP Dibrugarh to file a fresh application. As the earlier application was of the year 2018. The petitioner accordingly filed a fresh application in April 2023.
Then still
Be that as it may, Ms. U. Sharma shall obtain instructions as to why no action has been taken on the petitioner's application for renewal of his gun license. It is made clear that if no information is forthcoming from the Deputy Commissioner Dibrugarh by the next day, the said official may be called for, maybe the personal appearance of the said official may be called for.
Date may be
This is the matter. Give a date.
22nd of
No, no,
April,
no.
my lord, April, no.
After some time,
April.
April.
My lord, please not you, Sharma, you ask me.
Now you does.
Lords, oblige me. Oblige me. May I please your lordship? What's your instruction not to receive? May I pay?
Miss,
Amdas.
why not received? Miss M. Das is granted 3 weeks time to obtain instructions.
Deeply
This is the matter of 3 weeks.
Deeply agreed.
Well, no hurry, Mr. Council. Your bills are which year? Your bills pertain to which year?
Yes. 21.
Not one completion.
No hurry.
21.
No hurry, Mr. Council. You have not gone, we have not sent you to civil court. So be happy you are here. Yes, next.
This case, we are filing our affidavit in opposition on behalf of respondent number 5, Lordship, today, Lordship.
Item?
36.
Okay, Mr.
SR Borwa,
Submit that he will be filing his affidavit in opposition today.
today, on behalf,
Have you given a copy?
will serve with
Will
the,
not receive.
You will not file today, I don't think.
no, it will be filed.
It will be
Actually,
filed. But you have to give a copy to her
No,
first.
no, actually, we called his senior, he told to serve the copy to the clerk. R. Sharma.
Okay, today, huh? Huh?
We've not received yet.
No, he asked to serve it to the,
Now she's going to follow you, you give it to her.
oh, okay, okay.
You follow him.
Sure.
Okay. You follow. List the matter after a week. In the meantime, the petitioner may file affidavit in reply.
Lords, oblige.
Okay.
So follow him. He might run away otherwise.
Lordship, I may be granted 3 days of time for furnishing an extra copy to my learned friend.
No copy has been
After
sent.
that, she will
Item?
proceed.
37.
37.
How much? 3 days time?
3 days time.
Why 3 days?
Maximum, Lordship. Maybe tomorrow. It is
Okay,
my
that's it.
prayer, Lordship.
Maybe your prayer, but then you don't seem to be in a hurry. Okay, right. Petitioner's counsel submit that he will submit a copy of the writ petition to Ms. M.D. Bora within 3 days. List the matter after 3 weeks.
Lordship.
Deeply obliged. ma'am.
Deeply.
Here, my lord, signed copy of the affidavit I have received, my lord, but some lines are not clear, my lord, and I've been told that registry will not accept it. I have called for the fair copy, my lord. So maybe fix in the next week, next Monday, my lord, by this time I'll file the copy, my lord.
Otherwise, I have my friend talk with me. It's a legally Lordship can it's not
My lord,
matter. Maybe
that's
because of
why it is with me because I'm
Admitted amount.
told by the office that it will not be accepted by the registry, my lord. Because of lines are light, my lord, in some pages not clear. So next week, my lord, Monday maybe fix, my lord.
Ms. Yudas submits that the affidavit to be filed is unclear. She accordingly seeks a week's time to file the same, to file a better copy of the affidavit.
Lord,
Praise allowed, list the matter. Give a date. Next.
oblige.
Supplementary motion 43. None appears to be appearing.
From the last date also, they did not appear.
Right. No one appears for the petitioner on call. Miss A. Lodha appears for the Water Resource Department. It is also noticed that none had appeared for the petitioner on the last 2 consecutive dates. In view of the above, it appears that the petitioner is not interested in pursuing the matter. No, 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 full stop. The writ petition is accordingly dismissed for non-prosecution.
Obvious your lordship.
May I please, your lordship? Your lordship may kindly give the last order dated 15/2/2024. Your lordship. The contractor bill pertaining to year 1991, your lordship.
What is this? What is this? 1,61,000?
This is the contractor's bill amount, your lordship. Bill amount.
I don't know. Yes, what to do, madam?
We need 1 month time, actually, lordship, there's a CBI, the file, all the records are with the special judges court, so we are not supposed to whether that petitioner is entitled for the bill or not, that is the
No.
main question here. If he is entitled, there is no doubt that it will be cleared, but lordship, as no documents of his bill or something is there, so lordship, it is not possible for the department to.
Why? Where is the documents?
Lordship, the documents are in the CBI code, lordship.
In the CBI code, then you ask for the documents.
We have asked for the documents, lordship.
Has it been given?
The judgment was already passed in 2016, your lordship.
Lordship, it's a
Yeah.
2018 matter.
Yes, so what do you think? It's not a spring chicken, this case. They're very old matter.
Whether these bills are admitted or not, whether
So
the.
you please check, madam, this 2018 matter.
Yes,
You had
lordship.
6 years. What are you doing for the last 6 years? 16, huh?
1 month's time, lordship, in this financial year. it is
No, not,
possible.
there's no question of financial year. When you can't check the documents, there's,
That
please
they-
do not insult my intelligence that way.
Lordship, in that case, they have to file the documents again, lordship. If they will file the documents again, lordship, we will. end up
What
accepting
document?
What documents?
the
Work order is
admitted-
there,
admitted bill
Huh?
amount- bills,
work
lordship.
order is there, statement of bill amount is there. Several you have acknowledged our representation.
Yes, lordship, we have.
Where is your affidavit? You write an affidavit, you make your affidavit. You just cannot deny anything by just putting your head under the ground. You cannot act like an ostrich.
Lordship, in that case, if the matter, if the 10 days time may be allowed, I will file my affidavit in that matter.
You have to file either way.
It's one.
You see, you have got to either admit or deny his averment.
We will file the affidavit, lordship, may only like more than 10 days time, lordship.
Miss, what is the name?
MM Kotoki.
MM Kotaki, learned counsel for the respondent submits that she will file affidavit within 10 days. Full stop. He further submits that the records of the case are in the CBI court. Full stop. If that be the case, the respondent should ask for inspection of the records from the CBI court, which I am quite sure will be allowed by the CBI court. This is the matter on, give a date. Date.
4/6.
Out here also, no?
45 item, my lord, this is infectious matter, my lord.
Right. No one appears for the petitioner on call. No one appears for the petitioner on call. It is also noticed, full stop, it is also noticed that no one had appeared for the petitioner on the last 2 occasions, on the last 2 consecutive dates. Full stop. the matter pertains to settlement of the mining area, is it?
Mining area.
Mining area for sand and gravel,
China and gravel.
for sand and gravel for 7 years,
7 years.
from 2017 to 2019. 2017 to 2024. Which is to expire on 31/3/2024. At page 12. As no one appears, no, Mr. D. Gogoi, Learned Counsel appears for the Forest Department. As no one appears for the petitioner. It appears that petitioner is not interested in pursuing the matter. First off, the writ petitions accordingly dismissed for non-prosecution.
48 and 49.
What to do?
Yes, Lordship.
Huh?
None appears on the last date also. And
No, that is all right, but what is the matter about?
Yep. As per mine, it's a old matter, Lordship. I've taken second copy also. Already, we have settled to somebody else by floating tender, Lordship.
Settled with somebody else.
After floating tender. So the period is also over.
When was the period? Two 2015? What is this? Cannot be.
2020-21 after 26. I have translated it. That is page 19. Lord.
2014-15 to 2021.
That's right.
Period of 7 years.
But already over.
Right. No one appears for the petitioner on call. So stop. It is noticed that no one had appeared for the petitioner on the last date also. Mr. P. Sharma appears for the AFDC and submits that the settlement of the fishery had been made. No, the settlement of the fishery for which this writ petition had been filed is for the period from 2014-15 to 2020-21. That is for 7 years. He submits that the fishery has now been settled with another person to a tender process. And as such, the writ petition has become infructuous. Next para. On considering the fact that no one has appeared for the petition on 2 consecutive dates, this court is of the view that the petitioner is not interested in pursuing the matter. The writ petition is accordingly dismissed for non-prosecution. IA is also disposed of. IA also disposed of, huh? What is that? What is this writ petition? Same.
Same.
Up to this is also up to 21 only. No one appears for the petitioner on call.
Same. Lord.
Huh?
Same period. Same fishery. Lord.
Let it be passed in the same. Let it be passed in the same order.
Same order.
Tag matters.
Obliged, sir.
39 orders.
This is those matters, review better they have filed, but all the affidavits have not been checked in all the matters. So we pray that we may have given little accommodation.
Your case is, but then they are grade two.
Yeah, grade 2, my.
We are not grade two. That
Huh?
we are not grade two.
Anyway, we'll see that.
Yes.
So what do you want? What do you want? What tagging? What tag?
We have filed a reply.
Objection.
Objection.
It is not in the record.
Not in all the cases. In some cases might have. All the cases it has not come.
It's the same thing.
Yeah, that's true, madam. Let it come any other day, madam.
Why? I don't like reviews of my judgment to be kept pending.
But what happened? Actually, senior advocate Mr. B.D. Das is to lead us.
Who?
B.D. Das. Earlier also he was there. Now he's on Lake, but in court number.
You are there. Why you want
No,
BP?
my lord. He will take it otherwise again because he's.
Out of 50, my lord, 15 numbers of staff notes have been paying their installment at the rate of 10,000 per month. 15 and 35 before discourse, my lord.
All are not paying. There is
15,
stay order.
15.
There is
Huh?
a stay order from the court.
15, my lord.
So what?
My lord, they have been paying, my lord.
They will pay. So good for them.
We have to pay also.
If someone pays, let them pay.
I'm just pricing this court, my lord. They are same category, my lord.
Maybe. But some do not go to court. Some are happy staying at home. Some go to court.
Yes, sir.
That's why
But is there, my lord.
that is why that
Yeah,
that
right is there.
huh?
Right is there, my lord.
See, some people just sit on the fence waiting for a decision of the court.
Yes.
And then that's why the Supreme Court has said that in some cases you cannot write piggyback on the orders given to some other persons. Anyway, it's what to do here half a time. When?
Any date, my lord, end of this month.
Why end of this month?
Because my lord, from 13th I will be little out, my lord.
From?
From 13th, my lord.
Till what? Which date?
For a week, my lord.
A week. Then after that. Give a week after that, right? On the prayer for adjournment made by Mr. S.C. Biswas. This is the matter. On, give it. Item 40.
On the other side is supposed to apprise this court when they will release the amount, admitted amount. Lordship, on the last occasion, we had informed that his due payment is included in the budget provision for this upcoming year. We seek some further time to know exactly on what stage the payment is.
How much time, every time you same thing, you'll argue. We have managed to adjourn this matter a long time.
They have admitted weeks may be granted, Lordship, just to put the department on notice about it. They have admitted on 4/9/2021, page 19.
Who is this Kotemna?
Lordship, the chief engineer of PH is actually not the current incumbent.
Not the current incumbent. What about this Dipendu Talukdar? Why is that erstwhile? Okay, one is erstwhile. One is Dipendu Talukdar. He's not the present chief engineer.
But it was, my lord, they have accepted page 19 on 4/9/20.
Mr. Counsel,
Yes, yes,
please try to understand.
yes, yes.
He's saying that even if this court was to take action,
My lord,
the respondent is no longer the chief engineer. That's what he's saying.
my lord.
So what's the point of you arguing and saying all this when we can't take action?
But subject, my lord, subject to, my lord,
This was violation was, in the year 2021.
Mr. Counselor, why don't you understand
Yes,
some
yes.
small thing?
My lord, my lord,
In a contempt case,
my lord,
when we want to force someone to obey the orders passed,
my lord,
we have to plead that person.
my lord. Absolutely.
Action can be taken only against that person.
My lord,
Now, this respondent number 2, he's saying that he's no longer the chief engineer.
my lord.
Then, isn't it your duty to implement the latest?
My lord.
I understand your problem, but then to help you,
My lord.
we have got to give orders to the correct person. Who is the chief engineer?
Perhaps the erstwhile chief engineer, here it is written that the person is the special secretary, lordship. If
Huh?
that is true, respondent number 1 is still holding the post of special secretary, then that.
No, at present, special secretary did that gone. Was special secretary a party in the repetition?
No, no. But he will be in a position to apprise lordship, that I believe. As a secretary lordship, he will be in a better position to.
Maybe in a better position, but we take action against only those who we can take action against. Special secretary is not a party here.
Who was directed?
No, no, it's not it. Even for special secretary, no, special secretary is Borua.
Page
Want to
12,
Yes,
page 12.
page 28.
different product, no, what cannot.
Yes,
Yes. But point number 2 to release.
my lord.
Lordship, just 2 more weeks, lordship may with that observation in that order, so that we can put the department into notice, lordship.
This is of 2022.
Yes,
No, I'm demanding what.
we have raised the demand, otherwise.
When did you raise? 2022 you raised? This,
has been
and this order has been passed in 2021.
In this year's budget, it has been included, Lord. We have.
It's not, you see, it's not a question of inclusion, it's a question of payment. Right. We'll give you 1 week's time. Otherwise, I'm going to call him and I'm going to give it to him. You see, you have got to do something. Right. As per the order dated 15/7/2021, passed in WPC 4852/2020. The respondent number 2 was to release the amount claimed by the petitioner. However, the same has not been done till date. Even though nearly 3 years have gone by. Mr. Yes, Mr. What's your name?
I got it.
I brought up. Shall inform this court as to why there has been why the respondents have not obeyed with the order of this court till today. This is the matter. Leave next week.
Item 41.
Please, Lordship. Lordship, this matter was relating to payment of outstanding bill of construction work, Lordship.
Huh?
Payment of outstanding dues, Lordship. But during the pendency of this writ petition, Lordship, the petitioner expired.
Oh.
So now we have filed this IA, Lordship, for substituting the name
Okay.
of the petitioner. Legal heir, his wife.
Right.
Wife.
Heard Miss S.C. Ahmed, learned counsel for the applicant, who is the wife of the deceased writ petitioner. Next para. The petitioner's counsel submits that the writ petition expired on 7/12/2022, leaving behind the applicant and the minor son. She accordingly prays that the applicant may be allowed to substitute her deceased husband like a writ petition.
Pleasure, Lordship. Lordship petitioner died on 7/12/2023 and he filed on IA 21/4/23. So its limitation period is over.
Huh?
The limitation period is over.
This is a
According
this
to
is
the-
a writ petition.
Limitation Act, schedule serial number 120, then it's for 90 days limitation.
This is a writ petition. This is not a civil suit or something like that.
Next.
So you object, huh? What do I write? Miss N. Bora? Huh?
Lordship.
What? No, what do I write? Do you object? You don't object? What? You say anything you want. What? Huh?
Object limitation period is over. So
Miss N. Bora learned counsel for the state respondent submits that she objects to the application for substitution in as much as the limitation period for substitution is over in terms of
90 days.
which provision?
Limitation next schedule serial number 120.
Schedule number
120.
120 of the Limitation Act. Yes, sir. On hearing on considering the submissions made by the counsel for the parties, this court is of the view that this being a writ jurisdiction, the Limitation Act need not be applied in toto in a writ proceeding. Accordingly, this court is of the view that the application should be allowed. The applicant is accordingly pleaded and is allowed to substitute the petitioner, the writ petitioner. The applicant shall submit a corrected cost title before the registry within a week. Then in the main case, you write, in view of the order dated today, passed in IAC 1082 of 2023. The applicant so is pleaded and is allowed to substitute a deceased husband like a writ petition. Next para. Ms. N. Bora shall obtain instruction and file affidavit with regard to the claim made by the petitioner regarding unpaid bills. Correct? Unpaid bills. Unpaid bills.
Lordship.
Unpaid bills.
Affidavit,
Is it filed?
yes, Lordship. Election Commission have already filed it.
Acha,
Earlier.
you give me this. That's why I got mixed up. No need. What have I said? No, that's not it. Already affidavit is ready. So, when do you want to hear?
Lordship, in Annex 5, we have already we have sent the Assam State Election Commission.
Okay, list the matter after 2 weeks. In the main case, you say, in view of order so empty as censor. Then, as pleadings are complete, list the matter after 2 weeks.
3 weeks.
3 weeks. Pleadings are complete, correct?
Lordship.
3 weeks.
Obviously, Lordship.